We're gonna have to turn. Jefferson County Court at Law number 2 is in session. The court is in session with the arraignment docket. First two cases are Amber Poe. Ms. Poe, would you please come forward with your attorney? Okay, court is in session and calls numbers 25 CCCR 2286, calls number 26 CCCR 0721. Both cases are styled the state of Texas versus Amber Michelle Poe. Ms. Poe, is that your full name?
Yes, sir.
Ms. Poe, would you please raise your right hand? Ms. Poe, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Ms. Poe, you may put your hand out. How are you doing, Ms. Poe? I'm doing fine. Thanks for asking. Ms. Poe, you're represented by your attorney, Attorney Wright Kimler. Mr. Kimler, how are you doing?
Well, thank you.
And Mr. Kimler, do you waive a record in Mr. Poe and Ms. Poe's cases?
So,
State is represented in this case by Attorney Samuel Masradian. Mr. Attorney Masradian, how are you doing?
Doing well, Judge. Thank you.
Now, Ms. Poe, in cause number 25 CCCR 2286, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Amber Michelle Poe, on or about April 9th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault causing bodily injury. Ms. Poe, do you understand what you have been charged with? To this charge, Ms. Poe, how do you plead? Guilty, not guilty, no contest?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty?
Yes, sir.
Ms. Poe, I also have before me a document on my computer tablet that is titled Misdemeanor Plea Admonishments. This document is also labeled as State's Exhibit number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials, AP on the line next to a box that says check guilty. Did you place your initials on this document? On page 3 of this same document, there is a signature above the line that's titled defendant. Is this your signature? And on the next document that's titled trial court certification of the defendant's right of appeal, you recognize this document.
Yes, sir.
And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes,
The
sir.
second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Also, where's the discovery certification?
certainly.
There.
I also have before me, I don't have numbers, so.
I didn't have it in front of me.
Okay, I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant? And Ms. Poe, before you signed and initialed all of the documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
Did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
State up or states one, Your Honor.
No, Judge.
Okay, no objections. State's Exhibit number 1 will be admitted. And Ms. Poe, are you a citizen of the United States?
Yes, sir.
Mr. Kimler, you've advised and counseled Ms. Poe. Is there any evidence that she is currently mentally incompetent to stand trial? And Ms. Poe, your attorney, Mr. Kimler, has advised and counseled you.
Yes, sir.
Are you satisfied with his representation? Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Poe, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
That'll be 30 days in the county jail, credit for time served.
She has 41 days credit.
Yeah, what did you put on it?
30 days.
30, that's fine. 40 is 30 days credit for time served anyway. Okay.
You should get it.
So, Ms. Poe, the state is offering that you serve 30 days in the Jefferson County Jail. You will not be required to serve any more time in the Jefferson County Jail because you've already served 30 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. What that simply means is that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Ms. Poe, do you understand the state's offer? And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Ms. Poe, I'll follow the plea bargain agreement that you have entered into with the state. Now, Ms. Poe, we will move on to your second case. And your second case is cause number 26CCCR 0721. And in this case, I have before me on my computer a document that is titled Information. And in this information that was filed by the Jefferson County District Attorney's Office, it alleges that you, Amber Michelle Poe, on or about, it alleges that you, Amber Michelle Poe, on or about November 27th of 2025, while you were in Jefferson County, Texas, that you committed to Class A misdemeanor offense of burglary of a vehicle. Ms. Poe, do you understand what you have been charged with?
Yes, sir.
To this charge, how you plead? Guilty, not guilty, no contest.
Yes, sir.
Now, you're pleading guilty freely and voluntarily.
Yes, sir.
And are you pleading guilty because you're guilty?
Yes, sir.
Ms. Poe, I also have before me a document on my tablet that's titled Misdemeanor Plea Admonishments, also labeled as State's Exhibit number 1. Do you recognize this document? And is on page 2 of this same document, there's a set of initials, AP on the line that's checked guilty. Did you place your initials on the document? On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document, there's titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? At the top, there are 2 boxes checked. The first box is checked, states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box is checked, states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that's titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? At the top of these before you sign and initial all of these documents, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? State, you like to offer State's Exhibit number 1?
Yes, Your Honor.
No objection.
No objection. State's Exhibit number 1 will be admitted. And Ms. Poe, I will find that you are mentally competent to stand trial. I will accept your plea of guilty. I will find that your plea and waivers was freely and voluntarily given. I also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your
And
Honor.
what's the agreement?
30 days in the county jail, credit for time served of 30 days.
Okay, Ms. Poe, the state is offering that you serve 30 days in Jefferson County Jail. However, you will not be required to serve any more time in the Jefferson County Jail because you already served 30 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay any court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Ms. Poe, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in this case is fair and just? And do you accept the state's offer?
Yes, sir.
Ms. Poe, I'll follow the plea bargaining agreement that you have entered into with the state. Ms. Poe, this will conclude your case. If you do not have anything else holding you in jail, you should be getting out of jail today.
Yes, sir.
All right? Now, Ms. Poe, you're gonna stand at the end of the table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go. And you have a blessed day.
You too. You can sit down right there, Paul. I'm pregnant.
Oh, there you
Okay. You can turn that camera back around.
Okay.
Okay, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court at Law Number 2. You have been asked to come to court this morning for what is called an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with and what your rights are concerning your case. Now, the case that you have in this court is a misdemeanor case. It is a criminal misdemeanor case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your more serious type of criminal offense, whereas your misdemeanor cases are normally referred to as your petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and a possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and a state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. Now, if the person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 8 years, and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those type of punishments because, as I mentioned to you earlier, your case is not a felony, it's a misdemeanor. Now, misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the class A misdemeanor, the class B misdemeanor, and the class C misdemeanor. Now, if a person is convicted of a class C misdemeanor, the convictions is in city court or JP court. They only come to this court when the person appealed the case, and they get a whole new trial in this court. We call that a trial de novo, but anyway, you get a whole new trial. It comes to this court. Now, the punishment range is the same. Now, I'll just give you an example of a class C misdemeanor. Like, for example, not having your seatbelt on. while you drive. Or speeding, okay? Those are class C misdemeanors, okay? Now, if a person is, appealed the case, it comes here, the range of punishment on a class C misdemeanor is a fine only. They cannot be given jail, it's just a fine. And the fine cannot be above or exceed $500. So now they can't be sentenced to jail because it's a fine only. Now, however, if they fail to pay the fine, or if the fine was converted to community service because they couldn't pay it, and they failed to perform the community service, then the court can issue what is called a capias pro fine. What a capias pro fine is, it just simply means it's a warrant for the person arrested for them to either pay the fine or sit the fine out in jail. And if they sit the fine out in jail, for every 1 day that they sit in jail, $100 will be credited toward the payment of the fine and court costs. Okay, $100. So if they sit in jail 1 day, that's $100. That can be credited toward the fine and court costs. Now, the next highest misdemeanor is a class B misdemeanor. Class B misdemeanors, the range of punishment for a class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail. Or they could be given a fine that does not exceed or be above $2,000, or they could be given both such fine and jail time. Now, the highest misdemeanor is a class A misdemeanor. The class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or they could be given a fine that does not exceed $4,000, or they could be given both such fine and confinement. Now, a person may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation. That simply means that if a person gets placed on that type of probation, they will not have a conviction on the record. And if they complete the probation, the case will be dismissed. It would not result in a conviction on their record, and they may qualify, they can get what is called a non-disclosure. Non-disclosure is where their record is sealed to the general public. Now, the operative word is the general public. The general public cannot have access to it. So, for example, let's say you applied for a job at, say, ExxonMobil, right? And you have non-disclosure. You had a case, you had unadjudicated probation, you got a non-disclosure. They do a criminal background check. Guess what? They won't be able to see that. Why? Because it's sealed. Okay, they're part of the general public. It's sealed to them. They cannot see it. All right. Now, the government, in fact, the police department can. But for example, there are certain agencies, governmental agencies, that can have access, but most of the public is general public. Okay, and so they cannot have access to that record. Now, the other type of probation is adjudicated probation. We had unadjudicated probation. Now we have adjudicated probation. The difference between the two is with adjudicated probation, it does result in a conviction on the record. However, there's something that is called judicial clemency. What that means, it's similar to a pardon. Okay, the judge can set aside your conviction, and you will not have this conviction on your record. Now, in order to qualify, 3 things has to happen. 1, you have to successfully complete probation. 2, there cannot be any more time left on your probation. And 3, the probation office has to successfully discharge you, meaning let you off of probation. If those 3 things happen, you may qualify, you can qualify for what is called judicial clemency. Okay? Now, if you get another conviction later on after receiving judicial clemency. We call that a subsequent conviction. Then the case that you received judicial clemency on can be resurrected, revived, brought back up, and it can be used against you. But if you don't get another conviction later on, it's gonna stay sealed. You understand? It's gonna be dead. It's not there. So it'll never come back up. All right. Now, the next thing I need to talk to you about is your rights. One of the rights that you have is a right to have an attorney. That clipboard that you have before you, I'm going to go over that paperwork with you. The first document is titled, it looks like this, it's titled Judge's Explanation of Rights to Defendants Without Attorney. Okay, everybody should, you need clipboard? Yes, okay. Okay, yeah, make sure everybody have a clipboard. Everybody have a clipboard. Who does not have a clipboard? Okay, so everybody have a clipboard, that's good. All right, so the first document, and you know what I'm gonna do? I will constantly refer back to this document as I go along. Because before we finish, everybody's gonna make a choice at the bottom. Everybody's gonna make a choice, and we'll get to that. But at the top of this document, it states that as a defendant in a criminal case, you have a right to have an attorney, right? It states that here, as a defendant in a criminal case, you have three options. Number one, and we're talking about three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, these little sentences, one sentence paragraphs below number three will explain everything that I just said. Okay. For number one, for example, it says, the first one sentence paragraph, if you want an attorney and you can afford to hire an attorney, your case will be reset. Reset means you'll be given another court date to give you time to hire your attorney. The next one sentence paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request or you may ask the court to appoint an attorney to represent you. But before you can do that, you must first fill out a financial questionnaire. The financial questionnaire is a 3-page document that is titled Affidavit of Interest or Jefferson County Affidavit of Interest. And that 3-page document is on the clipboard. Now, this is only for people who will be requesting a court-appointed attorney. If you are not requesting a court-appointed attorney, you don't have to worry about reading and signing this. Only people who will be requesting a court-appointed attorney, okay? So for those individuals who will be requesting a court-appointed attorney, you have to fill out the first page of this document, and then you'll go to the second page, and on the second page at the top, it says Defendant's Oath. You have to fill out the top portion, and then to go to the middle portion where it says Unsworn Declaration by a Defendant, you'll fill that out and then you'll stop. All right. Now, again, that's only for people who would be applying for a court-appointed attorney. Now, going back to this first document, this third sentence is for people who will be representing themselves. Let me explain that to you. You have a right to waive or give up your right to have an attorney. You have a right to represent yourself. Okay? And if you represent yourself, you are acting as your own attorney. Okay? Now, just like the attorney can talk to the assistant criminal district attorneys or the prosecutors, because you are representing yourself, you are your own attorney, you will be able to talk to them as well about your case. Okay? Right now, we have two prosecutors, but we have one in here now, and that's Attorney Samuel Masradian. That's the gentleman sitting in the tape right here. So you have an opportunity to talk to him. For example, when lawyers talk to the prosecutors, they see if they can work out a settlement. The settlement is called a plea bargain. They call it a plea bargain. And so, let's say, for example, you represent yourself. Okay, you have an opportunity to talk to them to see if y'all can reach a settlement on your case. Okay, let's say, for example, you say to yourself, you know what? I want to see if I can get probation. Unadjudicated probation or adjudicated probation. Then you have an opportunity to talk to them to see whether or not they'll offer you probation on your case. Or you might say, well, I want to see if I can get a fine. Some people say, well, I want to see if I can get credit on the jail time that I already served. Okay, you can talk to them about that. Now, so that third paragraph down there is that one sentence paragraph says that you may not speak to the prosecutor unless the prosecutor is the assistant criminal district attorney. You may not speak to the prosecutor unless you first sign a written waiver of your right to be represented by attorney. Now, this is only for people who will be representing themselves. The written waiver is a one-page document that is also on the clipboard. And it is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You have to read and sign this document stating that you know you have a right to have an attorney, you waive your right to have an attorney, you want to represent yourself. Boom. And then you'll have an opportunity to talk to them. Okay, now the next thing okay, now the next paragraph here states that be aware that the dangers and disadvantages of self-representation. Waive your right to an attorney and represent yourself may result in the worst outcome for you, including your case, including the loss of significant rights and opportunities related to military service, possession of firearm, housing and public benefits, child custody, immigration status for non-citizens. Now, if the last sentence here says that, for example, it states that if you are representing yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Or you can hire an attorney. Now, let me explain that to you. Let's say you represent yourself. And let's say you talk to the prosecutor. And let's say you want a fine only, right? And let's say they say, well, I'm not going to offer you a fine, I'm going to offer probation. And you say, well, I don't want that. And you can say, Judge, I want to change mine, I want to hire my attorney, or I want to see if I qualify for a court attorney. You can do that. Okay? So represent yourself, you can see what they say, and you say, I don't like it, boom. You can ask for a court appointed attorney, you can tell the court you want the time to hire an attorney. You can do it. That's what that last sentence said. And they say you can do that. You can request that an attorney be appointed to represent you at any time. So at any time after talking to them, you can make that request. Okay? Now, at the bottom of this document, as I mentioned to you in the beginning, everybody's going to make a choice. At the bottom of this document, there are 5 lines. Okay? If you would like to hire your own attorney, then you'll place your initials on the first line to the left. Okay, at the bottom, first line to the left, you're gonna sign and date it, and this is the only form you have to sign, you'll stop. If you have already hired an attorney, then you'll place your initials on the second line to the left, the name of the attorney on the line to the right, you'll sign, date it, and then you'll stop. And this is the only form you would have to sign. If you would like to apply for a court-appointed attorney, Then you'll place your initials on the third line at the bottom of this document, sign, date this form, and then you would have to fill out this document that is titled Affidavit, Jefferson County Affidavit of Indigence. You would have to fill out the first page, and on the second page, you'll fill out the top portion that's titled Defendant's Oath, and the middle portion that's titled Unsworn Declaration by Defendant, and then you'll stop. Okay. Now, if you have already been appointed a court-appointed attorney, then you will place your initials on the fourth line at the bottom to the left, the fourth line, the name of the attorney on the line to the right, sign this document, date it, and then you'll stop. If you would like to represent yourself, then you'll place your initials on the fifth line, okay, on the fifth line of this document. You will sign this form that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea. See this, to try, you read it and sign it, and then you'll stop. Okay? Any questions? Okay, no questions. All right. Now, okay, now, I need to go over some other rights that you have. One other right that you have a right to have a jury trial. That area that I'm pointing at, we call that the jury box. You see 12 chairs, but in Texas, in a misdemeanor case, you have 6 jurors, not 12. So 6 jurors will be selected to serve as jurors in your case. And what the jurors will do, they will listen to all the evidence that's being presented by the state and by the defense. They will listen to the arguments of the state and the defense, and then they will go back into the jury room behind that closed door, and they will deliberate. Once they finish deliberating, they can either find you not guilty or guilty. Now, you can waive or give up your right. That's what waiving means, you're giving up. So you can waive your right to a jury trial or give up your right to have a jury trial. And if you waive or give up your right to have a jury trial, you would not be having a jury trial. You still can have a trial though. The trial that you would have is without a jury. You'll have a trial by judge. We call that a bench trial. And the reason why they call it a bench trial, because that area that the judge sit in is called the bench. So you have a bench trial, and the judge will be the judge and the jury in the case. So the judge will listen to all of the evidence that's presented by the state, listen to the evidence that's presented by the defense, listen to the arguments of the state, listen to the arguments of the defense, and then the judge will apply the facts of the law and decide whether to find you guilty or not guilty. Now, if you decide that you did not want a jury trial, and you decide that, well, you want to enter a plea guilty or no contest, I'll explain that to you. You have a right to enter 3 pleas. You can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court you committed the offense that you've been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be fighting, or you will not be contesting the charges. Okay. Now, if you enter a plea of guilty or no contest, and you or your attorney would like to see if y'all can work out a settlement with the state, you don't have a plea bargain. If you have an agreed plea bargain, if y'all come to an agreement, we call that an agreed plea bargain. Now, if you cannot come to an agreement with the state, let's say you want, say, a fine, right? And let's say they're offering probation. And you say, well, I don't want probation. As I mentioned earlier, you can change your mind. And then you get that, you don't have an agreement. And your next option would be to go to the judge and see if the judge would give you the fine that you're asking for. Okay, we call that an unagreed plea. But if you have an agreed plea bargain, let's say you want a fine, and they give you a fine, that's, y'all agree, I have an agreement, we call that an agreed plea bargain, okay? Then it comes before the judge can do one of two things. The judge can accept the agreement or reject the agreement. And if the judge rejects the agreement that you made, then you can tell the judge, I take back my plea. In essence, I'm not pleading guilty, I'm not pleading contest. Right? The law gives you a right to withdraw your plea if the judge doesn't go along with the plea bargain. Okay? Now, if the judge does go along with the plea bargain, and let's say in 90 days, not in 90 days, in 30 days, you would like to appeal your case, then you have to get permission from the judge that went along with the plea bargain. And then if the judge gives you permission, then the case is gonna leave this court, it's gonna go upstairs to the Ninth Court of Appeals for them to review the case to see whether or not you've been wrongfully convicted. Or the court committed an error by convicting you. And then there are 4 judges up there, 4 justices, they will review your case. They can do one or two things. They can grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, case over. Or they can send the case back down to this court, order this court to give you a whole new trial. Now, if they deny your appeal, guess what? You can appeal it to the highest court in the state of Texas, the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals located in Austin, Texas. And the justices on that bench who will review the case, and they can do one or two things. They can grant or deny your request. Now, you would have to file what is called a pro se petition for discretionary review. I'll explain that to you. Pro se means basically self, by myself, for self, for me, okay? And so, when you're saying you're pro se, that means you don't have an attorney, you represent yourself, and you have to file what is called a petition for discretionary review. You're petitioning the court by yourself. You're asking them to review your case, to see whether or not your appeal should have been granted, see whether or not this court committed an error by wrongfully convicting you or committed an error by convicting you. And they can do one or two things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty, the case over. Or they can send the case back up to the Ninth Court of Appeals with orders, or they can send it back down to this court with orders. Now, if they deny your petition at that point, your conviction will stand. Now, if you are unable to reach an agreement with the state, we call that and you still want to enter a plea of guilty or no contest. And then at that point, you'll be asking the judge to give you what you request. Okay? You ask for a fine from them, they didn't want to make that offer. Now you have the option to ask the judge to make that happen. That's called an unagreed plea bargain. Okay? Okay. Now the next thing, you have a right to have witnesses that come to court. You go on trial, you have a right to have witnesses. That area that has the microphone in front of it with the chair, we call it the witness stand. And what witnesses do, they'll come to court, they can testify for you or they can testify against you. If you represent yourself, you can ask a question. You have a lawyer, they can ask you a question. We call that the direct examination or cross-examination. Now, if you do not want to have if you do not want to call any witnesses to come, you can waive your right to call witnesses. Now, just because you don't call witnesses does not mean that the state will not call witnesses, because they will be calling witnesses in your case. Now, you also have something, we all have this right, it's called the Fifth Amendment right against self-incrimination. I know sometimes on television, you might have watched a television lawyer go up to the witness stand and want to ask the witness a question, the witness say, I take the fifth. And what that means is, I'm not saying that. The United States Constitution, the Fifth Amendment of the United States Constitution gives you a right, gives us a right to remain silent. And if you think about it, it makes sense. Why? Why does it make sense? Simply makes sense because the state of Texas or the government has the burden to prove that you're guilty of what they charge you with, right? You don't have to prove yourself guilty. Right? That's their job. So you just have to tip it. I take the fifth. Nothing they can do about it. The state, the government, the DA laws cannot force you to take the witness stand if you exercise or invoke your Fifth Amendment right against self-incrimination. Now, you can waive it, meaning that you can give it up, and you can take the witness stand if you desire to do that. All right. Now, the next right that we have, you have a right to have what is called discovery. And the reason why I pointed over there is because, you know, the government or district attorney's office has a file on everybody that has a case, right? Now, discovery means you have a right to see all the evidence that's there. You have a right to have access to that. You have a right to have access to your statements, witness statements, police reports, lab reports, audio recordings. You have a right to have video recordings, photos, documents, whatever evidence that they have, you have a right to have access to that. That's called discovery. Now, you can waive or give up the right to have discovery. If you waive or give up the right to have discovery, you're saying that you're gonna have access to it. Now, everyone that's here for a case, a charge has been filed against you, you've been arrested, placed in a county jail, you're out of jail on bond, you're either out of jail on a cash bond, which means you pay the full amount of the bond to get out of jail, you're out of jail on a surety bond, which means you pay a bondsman a percentage of the bond to get out of jail, or you're out of jail on what is called a personal recognizance bond or a PR bond, which means you didn't have to pay anything to get out of jail. You were released under your own personal recognizance with a promise to appear here today. I've said that to say this. Every day that you spent in jail, you could be given credit for the time towards your sentence. Okay, for example, all right? Earlier, before we started the raid, everyone in here watched a plea that took place with the lawyer and his client. The lady had 30 days, she had already served in jail. The state offered her 30 days, which means she did not have to serve no more time. Because the time was already served, called that credit for time served. Okay. So, using that as an example, every day that you spent in jail can be used as credit towards your punishment. Now, the operative word is every day. Let's say you were booked in the jail at 11:59 p.m. last night. And let's say you got out of jail 2 minutes later at 12:01 a.m. this morning. Guess what? That's 2 days credit. Why? Because it's 2 different days. It doesn't have to be 24 hours, 48 hours, you know. It's just it was Monday, now it's Tuesday. 2 different days. So you get credit for 2 days. Okay? And every day that you spend is credit at $100 per day that go towards your punishment. So for example, if you spend 5 days in jail, state is offering you 5 days in jail, you would then have to spend 5 days in jail. Why? Because you already served 5 days in jail, therefore you be given credit for the time that you've already served. Now, if the state is offering 7 days in jail and you spend 5 days in jail, we subtract 5 from 7, that leaves 2. That means you have to serve 2 days in jail. Now, if the state offered a fine, so for every day that you spent in jail, you are credited at $100 per day that can go towards your fine and court cost. So if you spend 5 days in jail, guess what? That's $500 that can go towards your fine and court cost. So if the state is offering you $500, fine and court costs of $500, that means you don't have to pay that. Why? Because you already spent 5 days in jail. The time you spent in jail will be applied to the fine, and it will be taxed and retired, and you won't have to pay anything. Now, if they are offering $700 and you spent 5 days in jail, that means you have $500 credit. We subtract 500 from the 700, that leaves what? 200. And you'll be required to pay it on the day that you take care of your case. Now, if you can't pay it, no problem. Because we can put you on what is called a payment plan. Where you can pay it off in small monthly installments until it's paid off. Now, let's say, even if they put you on a payment plan, you still do not have the income to pay it, no problem. Why? Because we can convert the fine and court costs to community service. And so for every 1 hour of community service that you perform at a nonprofit organization, $12.50 will be credited toward your payment of fine and court costs. So in our scenario, you're $200. If you work 8 hours, community service 1 day, that's $100. So you work 2 days, 2 8-hour days of community service, guess what? That's $200 you paid off, that's it. Okay? Now, Jefferson County has a program for people who hadn't been in trouble before. When I say been in trouble before, I'm talking about having cases filed against you. Okay? And what they will do, once you get into the program and complete the program, they will dismiss the case. And once the case is dismissed, guess what? You can get it expunged from your record. Expunged, erased, deleted, or wiped off from your record. It's gone. Okay, that's an expunction. Now, in order to qualify for the program, that's called pretrial diversion, that's by the district attorney's office. 3 things has to happen. 1, it has to be your first time getting 1 or more cases filed against you. It could be more than 1 case. And 2, you have to have an attorney to help you get in the program. The attorney could be appointed, or if you want to hire, that's fine. You don't have to be hired. You can be a court-appointed attorney that can get, and that can help you with the application process. And 3, it cannot be an offense for unlawful carrying a weapon or resisting arrest. But for all other offenses, you may qualify. Now, Jefferson County District Attorney's Office has another program that is called Veterans Court. It's for veterans only. All thing you have to do to get in that program is be a veteran of any one of the branches of the United States military. And with that program, you get into the program, you complete the program, they dismiss the case, and you can get that expunged from your record. Okay? Now, this court, County Court at Law number 2 of Jefferson County, Texas, has a program that God led me to start within the first 100 days of taking office in December of it started in March of 2017, within 100 days of taking office. The program is called the CSI program. CSI is an acronym that stands for Community Safety Initiative. It is a program that is designed to address the issue of what we call recidivism. And what recidivism is, which is people committing crime, they continue to commit crimes over and over. And so the CSI program is designed to address that, to stop it from happening. And with the CSI program, we have partnerships with various agencies in our Jefferson County region. And one of the agencies that we have a partnership with is Spindletop. Spindletop is our local mental health center. And what they would do, first of all, they have the expertise because they have doctors and counselors and other personnel who can address people who have mental health issues. Now, you do not have to be incompetent or insane to participate in the program. You can just simply suffer from depression, anxiety, or any other host of mental illnesses, and they have the expertise to address your mental health needs. Now, what they will do, Spindletop, they normally here on Tuesdays, and what they normally do is they can do a private interview, either in the jury room at their facility, by telephone, or by text, whichever is convenient for the individual. And they can develop what is called, they can do an assessment to determine what the mental health issue may be. And then they can develop a treatment plan for either outpatient or inpatient treatment to address your mental health needs. If you have issues with drugs or alcohol, well, Spindletop has a program that is called ATAR. It's ATAR, ATAR. And it stands for, it's an acronym that stands for Addiction, Treatment, and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OSAR. OSAR, OSAR is an acronym that stands for Outreach, Screening, Assessment, and Referral. Both of those programs of drug and alcohol recovery programs. And what they would do, they can do a screening, a private screening. They can assess, do an assessment to determine what your drug and alcohol problems are. And then they can develop a treatment plan for either outpatient or inpatient treatment. If you are unemployed, or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a program or who has a partnership with Lamar University. Lamar University has a program that is called CICE. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in any one of those areas, they will help you to get a job in the area that you're trained in. If you have not graduated from high school, or if you do not have your GED, your graduate equivalency diploma, Spindletop has a GED program, and CICE has a GED program where you can get your graduate equivalency diploma. Now, both of these programs, all of these programs that I'm talking about, does not cost you anything. They're free. Does not cost you anything but time. And I like to say in this quote, we don't just give time. We take our time. That simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to county court at law number 2 in Jefferson County, Texas, we do not have court as usual, we have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs that I just mentioned, just let us know, and we can get you on the road to living your best life. Now, the paperwork that you have before you, if you haven't finished, we're gonna give you time to finish the paperwork. If you need help filling out the paperwork, our core personnel, including myself, will be happy to help you finish filling out the paperwork. Now, once the paperwork is finished, we will bring you up before the bench, one at a time, and we're gonna put you into one of 3 categories. One, you wanna hire an attorney. If you wanna hire an attorney, the case will be reset, which means you'll be given another court date to give you time to hire an attorney. 2, second group, if you would like to apply for a court-appointed attorney, then if you qualify, your court-appointed attorney will be appointed before you leave here today. And 3, the other group is if you like to waive your right to attorney, represent yourself, see what the DA is talking about regarding your case. If y'all come to an agreement, or if you come to the judge for the punishment and the case is disposed of or taken care of, it'll be taken care of today. Okay? Now, make sure at the top of that form I see D has his for it says State of Texas versus, and it's a line, print your name. Because if you like me, sometimes I can't read my own handwriting. So just print it, so we'll know who that paperwork is for, because your signature's already at the bottom, just print it on that line. Okay, now, If you need to use the restroom, there are two restrooms right out in the hall. There's one in front of County Court Law number 3. And on the opposite side, the one in front of County Court Law number 3 is for men. The one on the opposite side of the hall in front of the 172nd District Court is for women. If you would like to use the restroom, you'll be allowed to go out through the hall into the restroom, to use the restrooms. And when you finish, please come back into the courtroom. Because if you do not come back in the courtroom and you leave the courthouse, and your case is called, and you do not answer, then your bond will be forfeited. A warrant will be issued for your arrest. You will be arrested, placed back in the jail, placed in jail. You're gonna have to bond out of jail again, and guess what? We're gonna have to go through this all over again. Okay? So we don't wanna do that. So we're gonna try to get you in and out here as soon as possible. Before we do that, does anybody have a question? Anybody have any questions before we go into recess? The other thing I need to, yes,
Just a clarification, if we're gonna hire an attorney, is this only one form? Is there?
that's it. You only fill out that first page. Yeah. Okay, anybody, any other questions? Okay. Okay, so now be mindful that we're still in court. And so conduct yourself accordingly. Okay, all right, court will be in recess, and then what we'll do, we're gonna call you up and put you in line, and then we're gonna try to get you in and out as soon as possible. All right?
After you finish, can I see something? Papers before
Jefferson County Court Law number 2 is back in session. The court is in session with its arraignment docket. First case is cause number 26 CCCR 0600. Case of style, the state of Texas versus Michael Wynn Van Chow. Mr. Van Chow, would you please come forward? You get to stand right there. Your full name is Michael Wynn Van Chow.
Yes, sir.
How are you doing?
Good.
Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
That's right.
Mr. Van Chow, you may put your hand down. Mr. Van Chow, I have before me a document that is titled misdemeanor, well, that's titled Judge's Explanation of Rights to Determine, Judge's Explanation of Rights to Defendant Without Attorney. Do you recognize this document?
Yes,
And is this your signature on the line that's titled defendant?
yes.
Are these your initials on the line that state you would like to apply for you would like to hire your own attorney?
Yes, sir.
Now, Mr. Van Chow, before you sign and initial this document, did you read the document? Did you understand what you read? Is everything in this document true and correct to the best of your knowledge?
It is.
Okay, Mr. Van Chow, I read your answers. Your case will be reset to give you the opportunity to hire your own attorney. We're gonna give them that standard 30-day reset. You're gonna get your reset. Once you get your reset, you're free to go.
Okay.
And you have a blessed day.
Wait
Yeah,
there.
just have a seat in that first chair on the wall. We have anybody else that's ready? Oh, she got these.
Yeah, I got them.
What is the leader of us? And Charles Allen, both of them DWS. I'm gonna need some bond conditions. Yes.
He's not here, Judge. Elijah Ray is not here. He was not transported from jail.
Let me do this here. This is cause number 25 CCCR 0596. Case is filed in the state of Texas versus Billy D. Carell. Ms. Carell, is that your full name? Ms. Carell, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Carell, you may put your hand down. How are you doing, Ms. Carell?
Okay.
I'm doing fine, thanks for asking. Ms. Carell, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes, I did check court-appointed attorney, right? Yes.
Yes, and are these initials on the line that state you'd like to apply for a court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
And on page 2 of this same document, there's a signature above the line that's titled Defendant Signatures. Is your signature. Now, Ms. Carell, before you sign and initial these documents, did you read the documents?
Yeah.
Did you understand what you read?
Yeah.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Do we have a copy? Ms. Carell, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Lori Perazzo. Attorney Lori Perazzo will be given information to contact you, and you will also be given information to contact her.
Okay.
Our court coordinator will give you that information. But before she gives you that information, I need to give you some bond conditions.
Okay.
Let me see the original. And I'm gonna read these bond conditions to you, and you'll be able to get a copy before you leave. And it's titled Standard Bond Conditions in County Court at Law Number 2. Says following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds are executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3 does not apply. Condition number 4 does apply because your offense is determined by a second, which is listed as a subsequent offense under section 49.04 through 4906 of the Texas Penal Code. And condition number 4 states the defendant whose information charges any subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before 3 days after the date. And do you understand that condition?
Yes, I don't have a vehicle.
Okay,
I'm
so
driving.
you can't, so if you don't have a vehicle, you don't have one to put one on. Now, if you drive somebody else's vehicle, that vehicle need to have an interlock device
Yes,
on it.
I'm not driving. I have moved in with my mother.
I understand.
She bring me back and forth to work and. all
Okay.
that.
All right. Now, condition number 5, the defendant shall obtain, maintain, pay for, and have no violations with the ignition interlock mobile breath device. Any violation shall be grounds for revocation. Now, you have to get there's something that's called a mobile breath device.
Okay.
Okay, you would have to get that and provide proof of that to the court.
Okay.
All right. Now, condition number 6 states that the defendant must attend AANA meetings 3 times a week and provide proof to the court. And I have before me a document, Ms. Mosby, could you hand these documents to Ms. Carell?
And can that also be because I was doing AA meetings, I was having trouble getting back and forth, so I was doing online.
Yeah, that's still AA.
counts?
Yeah.
Okay.
Okay, now, with the AA meetings, that the first document that she handed you is a list of places that you can go to if you need to go to, those in person that's in our area. And the next document is a sign-in sheet that they sign verifying your attendance at AA. Okay, so if you go online, if they can give you something to verify that you did, yeah, and you could bring that to court when you come back to court every time, okay? Now, do you understand the bond conditions?
Yes, except for the device thing.
It's, she can,
To me, okay.
there's a place she'll let you know where you can go get your mobile rental, and then you're gonna provide proof to the court. She can give you either our fax number or you could bring it to the court. And if the court is not in session, there should be a lady behind the blue doors next to the court that you can go to.
Okay, and then I don't have to have that there today.
No, you have 3 days to do that. Okay? All right. Now, Miss Corral, you're gonna have a seat in that first chair. And wait for your name to be called. You have a blessed day. Charles Allen. Mr. Allen, your full name is Charles Edward Allen Jr. Mr. Allen, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Allen, you may put your hand down. How are you doing, Mr. Allen? You doing okay? Now, Mr. Allen, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigency. Do you recognize this document? On page 2 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature?
Yes.
Now, Mr. Allen, before you sign and initial these documents, did you read the documents? Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Mr. Allen, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Martha Provo. Attorney Provo will give information to contact you, and you will give information to contact her. Oh, give her copy of the bond condition right here. They're right here. And Mr. Allen, we have some bond conditions for you. The bailiff is going to hand you a document that is titled Standard Bond Conditions in County Code at Law Number 2. I'm going to go over these bond conditions with you, and it states that standard bond conditions in County Code at Law Number 2, following return of a criminal information in County Code at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3 does not apply. However, condition number 4 does apply because your offense of DWI is second, which is listed as a subsequent offense under section 49.04 through 49.06 of the Texas Penal Code. And condition number 4 states, a defendant whose information charges any subsequent offense listed under section 49.04 through 49.06 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator. Said device shall be installed at the defendant's expense with written verifications of such installation being submitted to the court on or before 3 days after today. Do you understand that?
Yes, sir. I don't get paid. I'm on disability. I don't get paid till the second.
Well, you're gonna have to provide proof. This is the court's order.
Okay.
All right. Now, defendant shall obtain, maintain, pay for, and have no violations with the ignition interlock device, mobile breath device. Any violation will be grounds for revocation. Do you understand that condition? And condition number 6, defendant must attend AA, NA meetings 3 times a week and provide proof to the court. And Mr. Allen, the bailiff is going to hand you a document that, we have 2 documents. First document is a list of places that you can go to get your to attend AANA meetings in our area. And the second document is that when you go to AANA meetings, they will sign the form. And you need to bring that form back to court with you to verify that you have been attending AANA meetings.
Yes, sir. I can do that online, you said?
Oh, I don't know. You got to check with them. That lady said that's what she was doing.
Okay, okay,
Yeah, I didn't tell. Yeah. Okay.
all right.
Now, Mr. Allen, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail.
Yes, sir.
All right. You can have a seat. All right. Yeah. Would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth? Sir? Mr. Knight, you may put your hand down. How are you doing, Mr. Knight? I'm doing fine, thanks for asking. I'm Mr. Knight. I have before me two documents. Well, two cases. They are cause numbers 26 CCCR 0566 and cause number 26 CCCR 0567. Both cases are styled the state of Texas versus Isaiah Deshawn Knight. And Mr. Knight, is that your full name? Okay. And again, Mr. Knight, how are you doing? You're doing good? That's good. Now, Mr. Knight, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a signature on the line that's titled Defendant Signature. Is this your signature? Now, Mr. Knight, before you sign and initial these documents, did you read the documents? You don't understand what you read. And is everything in these documents true and correct to the best of your knowledge? Mr. Knight, I read your answers. Based on your answers, meet your eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Charles Rojas. Attorney Rojas will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get that information, you're free to go and you have a blessed day. Please have a seat in that first chair on the wall. Here you go.
Are you gonna run through everybody who's not, doing any sort of plea thing, because we need a tablet? Because we don't have any working tablets at this point.
Okay,
Don't give
hold
them
on,
any
hold on a
working
minute.
tablet.
Okay, Jefferson County Court Law number 2 is back in session. The court is in session and calls number 25 CCCR 2304, case of style of state of Texas versus David Samuel Worsham. Mr. Worsham, is that your full name?
Yes, Your Honor.
Mr. Worsham, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Worsham, you may put your hand down. How are you doing, Mr. Worsham?
Fine, sir.
That's good, Mr. Worsham. You're represented by your attorney, Attorney Giles Cole. And Mr. Cole, how are you doing? And Mr. Cole, do you waive a record in Mr. Worsham's case?
We should.
And Mr. Worsham, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, David Samuel Worsham, on or about August 2nd of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense, terroristic threat causing fear of imminent serious bodily injury. Mr. Worsham, do you understand what you've been charged with?
Yes, Your Honor.
And to this charge, how did you plead? Guilty, not guilty, no contest?
No contest, Your Honor.
Pleading no contest freely and voluntarily?
Yes, Your
And
Honor.
are you pleading no contest because you do not wish to fight or contest the charges?
That is correct.
Mr. Worsham, I also have before me a document that is titled Misdemeanor Plea Admonishment, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, Your Honor.
On page 2 of this same document, there's a set of initials on the line next to the box that check no contingent, which means no contest. Did you place your initials on this document?
Yes, Your Honor.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, Your Honor.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, Your
And
Honor.
is this your signature on the line that's titled
Yes.
Defendant? At the top of this document, there are 2 boxes checked. The first box is checked, states that this is a plea bargain case and you have no right of appeal. Is that correct?
Yeah.
And do you understand that?
Yes, Your Honor.
At the second, I see you got 2 checks, but I think you missed the second box.
Yes, Your Honor.
We'll go ahead on and check it.
Okay, that's fine.
Okay, now the second box that's checked states that you're waiving your right to an appeal. Do you understand that statement?
Your Honor.
On page, on the next document that's on paper, that is titled Discovery Certification, do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled Defendant? Now, Mr. Worsham, before you signed any of these documents, did your attorney go over these documents with you?
Yes,
And did you understand everything that your attorney went on?
yes,
And is everything in these documents true and correct to the best of your knowledge?
yes, Your Honor.
Mr. Worsham, are you a citizen of the United States?
Yes, Your Honor.
State, you like to offer State's Exhibit Number 1?
So, no objection.
And no objection, State's Exhibit Number 1 will be admitted. Mr. Cole, you've advised in counsel, Mr. Worsham, is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Worsham, your attorney, Mr. Cole, has advised and counseled you. Are you satisfied with his services?
Yes, Your Honor.
Has he provided full, effective, and competent legal representation?
Yes, Your Honor.
Mr. Worsham, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The following essential terms are as follows. It would be 9 months deferred adjudication, a $250 fine, and 40 hours community service. Is that correct, Mr.
That's
Mayor?
correct.
40.
What's the court cost? 277. Oh, yeah, thanks. Okay, Mr. Worship. The state is offering that you serve 9 months deferred adjudicated probation during the 9-month probationary period. You'll be required to pay a fine of $250 plus court costs of $277. You'll also be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. And you will also be required to reimburse Jefferson County Court appointed attorney's fees of $350. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $196 a month. Are you able to pay the $196 a month?
It'll be tough.
Okay, so you're not able to pay,
No.
okay. Okay. Yeah, okay. Total.
I try.
Digital citizen.
It's not the house. It all has houses, I know. Is it?
20,
It's all.
30.
This doesn't. Oh, yeah, see, they was on that thing.
Okay, Mr. Worship, I'm handing your attorney a document that is titled Jefferson County Affidavit of Indigence. Could you review that document? Do you recognize that document?
Yes.
Is everything on that document still true and correct?
Wait a minute. This is my wife's income.
I know, but is it
Yes,
still
but
true,
it's
right?
still, yes.
Okay. Now, Mr. Worsham, the court is gonna find that you're indigent based on the finding of indigency pursuant to Article 42.15 of the Texas Code of Criminal Procedure. The fine in this case of $250 and court costs of $277 will be converted to community service. It will be converted to 42 hours of community service. The attorney's fees of $350 will be waived pursuant to Article 26.05 G-11 of the Texas Code of Criminal Procedure, so you will not have to pay that. The reimbursement fee of $15 will be waived pursuant to Article 102.018 of the Texas Code of Criminal Procedure, so you will not have to pay that. And the probation fee in this case will be reduced to the statutory minimum of $25 per month. You will be required to pay the urinalysis fee of $15 a month, so your total monthly installments in this case is $45 a month. Okay, would you be able to pay the $45 a month?
Yes.
Okay, you'll also be required to perform 40 hours of community service in addition to the 42 hours that was converted from the fine and court costs, which comes to a total of 82 hours of community service. And you will also be required to adhere to the other standard terms and condition of this probation. Now, Mr. Worsham, do you understand the state's offer?
Yes, sir.
Do you think the state's offer and the court's finding that you're indigent is fair and just?
Yes, Your Honor.
And do you accept the state's offer and the findings?
Yes, Your Honor.
Okay, Mr. Worsham, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Worsham, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record. And you may qualify for non-disclosure. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Okay?
All right,
So you're gonna have a seat in that first chair, wait for your name to be called because she has to redo the paperwork.
okay.
All right, and you have a blessed day.
Thank you, Your Honor.
Okay?
Appreciate you, Mr. Williams.
Okay.
Thank you, sir.
And you have a blessed day as well, Mr. Cole.
Thank you, Judge. Ladies, I'm truly grateful.
Thank you.
I'll see y'all tomorrow for January.
Thursday, today Tuesday. Yeah, come tomorrow so you can get to me.
Just make sure she got
Jefferson County Court Law number 2 is back in session. Court is in session and calls number 266 CCR 0574. Case is styled the state of Texas versus Kiana Jubert. Hey, Ms. Jubert, is that your full name? Ms. Jubert, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Jubert, you may put your hand down. How are you doing, Ms. Jubert? You good? That's good. Now, Ms. Jubert, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled, excuse me, that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you would like to apply for court-appointed attorney?
Yes,
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And on page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes.
Now, Ms. Juba, before you sign and initial these documents, did you read the documents?
yes,
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
yes,
Okay, Ms. Jubert, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you, and you will be given information to contact her. The court coordinator will give you that information. Once you get that information, you're free to go and you have a blessed day. Please have a seat in that first chair on the wall and wait for your name to be called. Yes, Joel. This person, William Miller, that should be, they did an evaluation on him in a felony case. I think that's the guy that attacked, yeah. Has it been deactivated?
I'm right in the middle, so I'm
Hmm?
I'm right in the middle.
Oh, okay. Daniel Torres.
Yeah, that was.
Torres? Okay. Oh, you keep working on something? Okay. Oh, wow.
Yeah, I'm not letting this iPad die.
Sounds like,
Wow.
I'm doing mine for the program, but I gotta remember to.
You need mine?
No, it's okay, but
Yeah,
I will eventually.
remember
Sign.
when I do it like that.
Yeah. Well, I have to get it in.
Remind me of those speech. Email. Yeah.
We got something?
If I can need to do.
No, this is
Oh,
Mr.
you need Just Tap?
Yes.
Oh,
He needs to do a dismissal.
oh. Let me do this here. Log out. Yeah.
Thank you.
Okay. That is Mr. Torres. Torres. How you pronounce your middle name?
Echevarria.
Echevarria? Okay, Echevarria. Okay.
Gilbert? No. Is your birthday? If you need before they. You have any questions before you close?
You could have a seat right there in that jury box until he's finished. You can just have a seat right there. That'll be fine. Jefferson County Court up on number 2 is back in session. The court is in session and calls number 26 CCCR 0624. Case is styled the state of Texas versus Daniel Echeverria Torres. Mr. Torres, is that your full name?
Yes, sir.
Mr. Torres, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Torres, you may put your hand down. How are you doing, Mr. Torres?
Doing good so far.
That's good. Now, Mr. Torres, you have a right to have a record made. That is, you have a right to have a court reporter to dictate or type everything that's being said in court today. However, you also have a right to waive your right to have a court reporter, which means you have a right to give up your right to have a court reporter. Do you waive or give up your right to have a court reporter?
Mm-hmm.
You do? Okay. Now, Mr. Torres, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Daniel Echevarria Torres, on or about March 29th of 2025, while you are operating a motor vehicle in a public place in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Echevarria, do you understand what you have been charged with?
Yes, sir.
And to discharge, Mr. Torres, how do you plead? Guilty, not guilty, or no contest?
Okay.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes,
That-
sir.
Okay. Now, Mr. Torres, I also have before me a document that is titled misdemeanor plea admonishment. This document is also labeled as State's Exhibit number 1. Do you recognize this document?
No.
Now, also on this document, we'll make a correction. This is a DWI It's Class B driving while intoxicated case, which is a DWI first. And the range of punishment for a Class B DWI is confinement in jail for at least 72 hours, but not to exceed 180 days, a fine not to exceed 2,000 hours, or you could be given both such jail time and a fine. Do you understand that? And I'm gonna check the box off that's titled, check that, just did one. That's titled DWI first, okay? Now, on page 2 of this same document, there are 2 sets of initials, and the initials are DE. The first set of initials are on a line that is titled nolo contendere, which means no contest. Did you place your initials on this document? The second set of initials are on a line next to a statement that reads, I do not request a discovery. I waive my right to discovery in this case and choose to enter a plea of guilty and no contest. You place your initials in the second location. On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document, there's titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? And Mr. Torres, before you sign, oh, where is this? His paperwork for the judge's explanation. The judge's explanation, the paperwork that we gave you.
Oh,
Yes. I also have a document, I have 2 documents on paper. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you like to waive your right to attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purpose of Entering Guilty Plea or Proceeding Trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Now, Mr. Torres, before you sign and initial all of the documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir. State offer states one, Your Honor.
Now, Mr. Echevarri, the state is offering state's exhibit number 1 to be used as evidence in your case against you. State's exhibit number 1 is the first document that I showed you on the tablet. It's the same document where I had to check off the first box. That's at least the third box that said this is the DWI first. It's the same document that have your initials in these 2 locations that you acknowledge. And it is the same document that has your signature on page 3. Is it all right for the state to use this document as evidence in your case? Okay. No objections. State's exhibit number 3 will, exhibit number 1 will be admitted. Mr. Echevarri, are you a citizen of the United States?
Yes, sir.
And Mr. Echevarri, is there any evidence that you are currently mentally incompetent to stand trial? Okay? Mr. Echevarri, I will accept your plea of no contest. I will find that you are mentally incompetent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt state. Do we have a plea bargain agreement?
We do, Your Honor.
And what's the agreement?
Be confinement in the county jail for a period of 90 days, probated for 6 months, a
Okay.
$400 fine, and DWI standard conditions.
Okay. We go to add alcohol. Any, you said any community service?
No, Your Honor.
Nope, okay, what, 0 community service, okay. What's the court cost?
$392.
3, 2, 3, well, that's 7, 20. 80. Yeah. Seven. Five. That's what it is. Just, oh. There. Should be it. Okay, Mr. Torres, the state is offering that you serve 6 months to 6 months probation, well, serve 6 months in the Jefferson County Jail. However, you would not have to serve any time in the Jefferson County Jail.
No, it'd be
Let me do
90
this here.
days,
It was 90 days?
probated for 6 months.
Oh, yeah. Okay, yeah, it is 90. Okay, the state is offering that you serve 90 over 6. Okay. 90 over 6. Make this here, that is gonna be, that's gonna be enough to fund. 18. 18. 18 on 7 divided by 5. Oh, okay. 361. Okay, now, Mr. Torres, the state is offering that you serve 90 days in Jefferson County Jail, but you would not be required to serve 90 days in Jefferson County Jail because you'd be placed on probation for a period of 6 months. During the 6-month probationary period, you will be required to pay a fine of $400 plus court costs of $392. You'll be required to pay a probation fee of $60 per your analysis fee. Let's go. Hold on a minute. Add it up, it's 90, it'll be 360 and 90. $360. See, there's 3, 7, 8, 11, that's
Okay. So I think thank you.
13 for this suit. Okay. 71. Okay, now, Mr. Torres, the state is offering that you serve 90 days in Jefferson County Jail. Have you not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 6 months. During the 6-month probationary period, you'll be required to pay a fine of $400 plus court costs of $392. You will also be required to pay a DWI conviction fine fee of $100. You're required to pay a probation fee of $60 a month, your analysis fee of $15 a month, and a reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $271 a month. Are you able to pay the $271 a month? You will also be required to attend and complete a DW education class and have an alcohol assessment. You will not be required to do any community service. You will be required to adhere to the other standard terms and conditions of this probation, and you're required to pay Jefferson County DW education and initial evaluation fee of $125 on the day of the police should for the evaluation be needed. You'll be required to pay an additional $50. Do you understand?
Yes, sir.
Now, Mr. Torres, do you understand the state's offer?
Yes, sir.
Do you think the state's offer in your case is fair and just? Do you accept the state's offer?
Yes, sir.
Okay, Mr. Torres, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Torres, if you successfully, Mr. Torres, you can stand next to the bailiff. Follow her direction. Once you finish following her direction, you're free to go. And you have a blessed day. All right. And we have the dismissal, is that,
Do Holmes next, Judge, because I know.
I thought I had a dismiss.
Yeah, Holmes has.
Oh, no, I was thinking,
You should have a dismissal on forward as
Forward.
well as
on who?
on forward.
No, not a dismissal.
There's a dismissal and a plea agreement on forward, yes.
Holmes.
Holmes, I'm sorry.
Holmes, yeah.
Holmes, my bad, my bad.
Okay, Nathan, Holmes Jr. Okay, Mr. Holmes. Just for the record, you and I are not related, is that correct? Yeah, we just had the same last name.
Duke, when people from Duke, then.
Newton?
Yeah.
My folks from Homer, Louisiana.
I'm sure after you ask him, but I don't.
Yeah, Homer. Okay, this is, okay. Mr. Nate. Okay. Let's see. Let me do this here. This is, 48 and 30. Okay, Mr. Holmes, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Holmes, you may put your hand down. How are you doing, Mr. Holmes?
Doing pretty good, man, doing pretty good.
That's good. Now, Mr. Holmes, I have before me two cases. First case is cause number 26 CCCR 0649. And, well, before we get started, Mr. Holmes, you have a right to have a court reporter to type down or dictate everything that's being said. You also have a right to waive or give up right to have a court reporter. You waive or give up? You waive it? Okay, now, Mr. Holmes, I have before me on my computer a document in cause number 26 CCCR 0549. And in this document, it alleges that you, Nathan Holmes Jr., on or about October 5th of 2025, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Holmes, do you understand what you have been charged with? And to this charge, Mr. Holmes, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Now, Mr. Holmes, I also have before me a document that is titled Misdemeanor Plea Admonishments. You recognize this document?
Yes, sir.
Now, Mr. Holmes, I'm going to,
Again,
yeah, I'm gonna check the third box that states that this is a DWI first. And this box states that the range of punishment for a Class B DWI is minimum 72 hours in the Jefferson County Jail to a maximum of 180 days in the Jefferson County Jail. You could be given a fine that does not exceed $2,000. Or you could be given both such fine and confinement. Now, Mr. Holmes, do you understand the range of punishment for a DWI
Yes, sir.
Class B? Okay. On page 2 of the same document, there are two sets of initials. NH, first set of initials are on a line next to a box. It's check nolo contendere, which means no contest. Did you place your initials on that document?
Yes, sir.
Well, on this line. The second set of initials are on a line next to a statement that reads, I do not request a discovery. I waive my right to discover. In this case, in choosing enter a plea of guilty or no contest, did you place your initials in the second location of this document? On page 3 of the same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? At the top of this document, there are two boxes checked. The first box is checked, states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box is checked, states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper, two documents on paper. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you like to waive your right to attorney and represent yourself?
Yes.
I also have another document that is titled Waiver of Counsel for Purposes of Inter Guilty Plea Proceeding Trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Now, Mr. Holmes, before you signed and initialed these documents that you signed and initialed, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct
Yes.
to the best of your knowledge? And Mr. Holmes, are you a citizen of the United States?
Yes.
State, you like to offer State's Exhibit number 1?
Yes, Your Honor.
Mr. Holmes, the state is offering State's Exhibit number 1 to be offered as evidence in this case. State's Exhibit number 1 is the first document that you signed on this tab, same document where I made, checked off the box saying DWI first. On page 1, on page 2, it has your locations in these two locations. And it has your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objections. State's Exhibit number 1 will be admitted. Mr. Holmes, is there any evidence that you are currently mentally incompetent to stand trial? Okay, Mr. Holmes, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what's the agreement?
That'd be a deferred adjudication for a period of 6 months with a fine of $400, DWI, first standard conditions, as well as an interlock device.
Okay.
Sorry.
Mhm. Yeah, and you're gonna dismiss this companion case?
Yes, Your Honor.
What's the court cost? Okay, Mr. Holmes, the state is offering that you serve 6 months deferred adjudicated probation. During the 6-month probationary period, you'll be required to pay a fine of $400 with court costs of $392. You'll be also required to pay a DWI conviction fine fee of $100, a probation fee of $60 a month, your announcement fee of $15 a month, reimbursement fee of $15. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the police. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total amount in installments, that is the total amount that you will be required to pay each month is $271 a month. Are you able to pay the $271 a month?
Yes, sir.
You will not be required to pay any court call, you will not be required to perform any community service in this case. However, you will be required to install an interlock device on any vehicle that you own or operate, attend and complete a DW education class, have an alcohol assessment, and adhere to the other standard terms and conditions of probation. In addition, the state will be dismissing the companion case cause number 26 CCCR 0648. Mr. Holmes, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer is fair and just?
Yes,
Do you accept the state's offer?
yes.
Mr. Holmes, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Holmes, if you successfully complete this probationary period, this case will be dismissed. It would not result in a conviction on your record. And you may qualify for a non-disclosure. You can talk to an attorney about a non-disclosure. Okay? Now, Mr. Holmes, you will stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go and you will get a copy of the dismissal as well in the companion case.
Just to be clear, the dismissal was based subject to forfeiture, not on the plea to this.
Oh, it is? Hold on, let me see. So there's a forfeiture instead of the dismissal is, so in this case, well, I'll call the case. Okay, in cause number 26 CCCR 0648, I have before me a document that is titled motion to dismiss. Do we have the form for the forfeiture?
There's one right there.
Did y'all, oh,
No.
Yeah, yeah.
You did that, all right.
no, yeah.
She's gonna print out the dismissal.
25 CCCR 2044 case of style, State of Texas versus Ebony Chapman. Ms. Chapman, is that your full name?
Yeah.
Ms. Chapman, would you please raise your right hand? You swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God. Ms. Chapman, you may put your hand on. How are you doing, Ms. Chapman?
How you doing?
I'm doing fine, thanks for asking. Ms. Chapman, you're represented in this case by your attorney, Attorney Jennifer DeLage. Ms. DeLage, how are you doing?
I'm doing great, Judge. How about you?
I'm doing fine, thanks for asking. Now, Ms. DeLage, I have before me a motion to dismiss. Is that correct, Ms.?
Yes, Your Honor.
Okay, and I've just signed this motion to dismiss. And Mr. DeLage, you and your client be able to get a copy of this motion. Once you get a copy, you're free to go and you have a blessed day.
Thank you, Your Honor.
You're welcome. Nathan Holmes? You just, okay. And this is cause number 26 CCCR 0648. Case is filed the state of Texas versus Nathan Holmes Jr. And Mr. Holmes, he was previously sworn in. Who is the weapon? Let me see. And Mr. Holmes, I have before me a document that is titled Motion to Forfeit. Do you recognize this document? And is this your signature on the line that's titled Defendant? Before you signed this document, did you read the document? I'm just actually, I could read it to you. It says that comes now as Assistant Criminal District Attorney of Jefferson County, Texas, and makes this motion requesting that the court enter an order pursuant to Article 18.19 of the Texas Code of Criminal Procedure, wherein the court orders the defendant to wit, and it's a Glock SNBYCV 689 and a Smith and Wesson. Well, the SN is the serial number. SBP 9943. The defendant has been notified that he or she is entitled to the weapon upon written request to the magistrate. However, the defendant is not requesting the weapon. Therefore, the weapon is being forfeited to the Groves Police Department in the state of Texas. Wherefore, the state of Texas heretofore prays that this motion be granted. Now, okay, do you understand this motion? And is everything in this motion true and correct to the best of your knowledge? Okay. The court is going to grant this motion to forfeit the weapon in this case to the Groves Police Department. And I also have a motion to dismiss this case. And I'm signing the motion to dismiss the case. You'll be able to get a copy of this motion. In order to dismiss this case, the case is being dismissed for forfeiture of the weapon to the Grove, or the weapons to the Grove Police Department. Okay? Okay, Mr. Holmes, you can get your copy of the dismissal from our court coordinator. No way. Torres, who else we have? We somebody named
Ford.
Scholar Ford. That's Scholar Ford. Three months difference. 3 months deferred. Hold on a minute. Class A, I think it might might be 6. I was got some excuses. Just write that somewhere.
I didn't think that was Class A, and it was.
No, I'm just saying, I don't know what
Oh.
it is. I'm just, what case is it?
Display of a fictitious license plate.
Okay,
It says on the phone.
okay.
Oh.
Let me see. I just read that. Let's see. Hold on.
Oh.
Okay, Mr. Ford,
Yes, sir.
would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Ford, you may put your hand down. How are you doing, Mr. Ford?
Great, and yourself?
I'm doing fine. Thanks for asking. Now, Mr. Ford, we saving the best for last.
Yes, sir.
All right, Mr. Ford, I have before me a document. Well, before we get started, Mr. Ford, you have a right to have a record made of this proceeding. That is, you have a right to have a court reporter to type down or dictate everything that's being said. You also have a right to waive your right to have a court reporter, which means you have a right to give up your right to have a court reporter to dictate everything that's being said. Do you waive or give up your right to have a court reporter in this case? You do? Okay. Now, Mr. Ford, I have before me a document that was filed by the Jefferson County District Attorney's Office. This document is titled Information. This information alleges that you, Scholar E. Ford, on or about September 2nd of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense, display fictitious license plate. Mr. Ford, do you understand what you've been charged with?
Yes, sir.
And to discharge, Mr. Ford, how do you plead guilty, not guilty, no contest? Are you pleading no contest freely and voluntarily?
Yes,
And are you pleading no contest because you do not wish to fight or contest the charges?
yes,
Mr. Ford, I also have before me a document on this tablet that is titled Misdemeanor Plea Admonishment, is also labeled State's Exhibit 1. Do you recognize this document?
yes.
On page 2 of this same document, there's two sets of initials. First set of initials on the line next to a box is checked no look contingent, which means no contest. And did you place your initials SF on this document?
Yes,
Second set of initials on the line next to statement that reads, I do not request discovery in this case. I waive my right to discovery and choose to enter a plea of guilty or no contest. Did you place your second set of initials on this document?
yes,
On page 3 of the same document, there's a signature above the line that's titled Defendant. Is this your signature?
yes,
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
yes.
And is this your signature on the line that's titled Defendant?
Yes,
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement?
yes,
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
yes, sir.
I also have a document that is titled Judge's Explanation of Rights to Defendants Without Attorneys. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you like to waive your rights to attorney and represent yourself?
Yes, sir.
I also have a document that is titled Waiver of Counsel for Purposes of that's titled Waiver of Counsel for Purposes of entering a guilty plea or proceeding to trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Now, Mr. Ford, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Ford, are you a citizen of the United States?
Yes, I am.
State, would you like to offer?
State's Exhibit 1, Your Honor.
Now, Mr. Ford, the state is offering State's Exhibit number 1 to be used as evidence against you in your case. State's Exhibit number 1 is the first document that I showed you on this tablet.
Yes, sir.
This is the same document that has your initials in these two locations on page 2 and your signature at the top on page 3.
Yes,
Is it all right for the state to use this document as evidence in your case?
yes, sir.
Mr. Ford, State's Exhibit number 1 will be admitted. Mr. Ford, is there any evidence that you're currently mentally incompetent to stand trial?
No.
Okay, Mr. Ford, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
Oops. Okay. What is the agreement?
There'd be a period of deferred adjudication for 3 months with a fine of $90.
$90 plus court costs. No community service.
No, no, sir. He was offered that or the fine, he chose the fine.
Okay, so it's $90 fine plus court costs
Yes, sir.
and 3 months deferred, okay. Okay, let's see. 90. What's the court cost?
277.
277. That's okay, I'll just explain, okay. Okay, now the state is offering that you serve 3 months deferred adjudicated probation. During the 3-month probationary period, you're required to pay a fine of $90 plus court costs of $277. You're required to pay probation fee of $60 a month, yearly fee, $15 a month, reimbursement fee of $15. Okay? Now, because the period is shortened,
Yes, sir.
when you shorten it, that means the amount per month is increased.
Mhm.
In essence, for example, if I divide, let's say I'm just picking up, say 1,000. Now, if I divide 1,000 by 10 months, that'd be 100.
Yes, sir.
But if I divide 1,000 by 5, it's 200.
Yes, sir.
Okay?
Yes, sir.
Now, when I total up the total amounts that you have to pay is $607.
Yes, sir.
Okay, but we don't divide it by 3. What they do, they divide it, they take off a month. And it's just so you can pay it up a month before you get off of probation.
Yes, sir.
So this is not being divided by 3, it's being divided by 2.
Okay.
So if it was divided by 3, because if it was divided by 3, we'll be looking at $202 a month.
Yes, sir.
But it's being divided by 2, so it's $304 a month. Okay, are you able to pay that? You able to pay it? Okay.
I
Now,
don't want to miss that.
yeah, we don't wanna, you either can or you
Extend it
can't.
one more
Okay.
month if we want.
I just, huh?
I mean, I'm just saying we can put it to be a 4-month deferred if that would make him able to pay it better, correct? If he's
Okay.
willing to agree to that.
Yeah.
Would you think that'd be better?
Yeah.
Okay. Okay,
That's-
okay, so now let me tell you what the amount is. I'm just gonna divide that by 3
Okay.
because it's 4 months. So that'll be
$202.
about $202 a month. You able to pay that?
Yes, sir.
Okay, so it'll be 4 months deferred.
Change it.
Okay. Okay, so it's 4 months deferred. Okay. Probation. And so that'll be $202 a month. Okay?
You feel more confident on that one?
Yeah.
You are? Okay. So that's why I had to explain it to you because I know when I looked at the amount myself,
Uh-huh.
I said, whoa. Okay, so that'll be 4 months deferred adjudicated probation.
Yes.
And the fine is $90 plus court costs of $270 plus a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. And you'll be required to pay an amount of $202 a month.
Okay.
Okay?
Yes, sir.
Now, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes,
You accept the state's offer.
yes,
Okay, Mr. Ford, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Ford, if you successfully complete this probationary period, this case will be dismissed. It would now result in a conviction on your record, and you may qualify for non-disclosure. You can talk to an attorney about the non-disclosure.
yes.
Okay, so Mr. Ford,
It's gonna be a few minutes, I don't know.
okay, just have a seat in that chair, wait for your name to be called. Once your name is called, you get your paperwork, you're free to go, and you have a blessed day.
All right, thank you.
All right. All right, and thank you, prosecutors, you're excused. Yeah. Hmm. Okay, that's fine. Y'all can have a seat. Something was on. She needed me to. No, Trina, would you come into the courtroom? Okay, everyone, please stand. I think.
Okay, they're ready now.
You may be seated. Jefferson County Court at law number 2 is back in session. The court is in session and cause number 24 CCCR 1826. The case is styled the state of Texas versus Logan Odebert. Let the record reflect that Mr. Odebert is present in court with his attorney, Attorney Ralph Kimbler. Let the record reflect that the state is present with Assistant Criminal District Attorneys, Attorney Farrah Nixon, who is sitting first chair, and Attorney Andrew Hubel, who is sitting second chair. Let the record also reflect that the jury is now present and seated in the courtroom. State, are you ready?
Yes, Your Honor, ready.
Defense, are you ready?
Ready.
Okay. Ms. Mr. Odebert, would you please stand? Ms. Nixon, would you please read the information?
In the name and by the authority of the state of Texas, come now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the county court at law of Jefferson County, Texas, that in Jefferson County, Texas, Logan Odebert, hereafter styled the defendant, heretofore on or about March 7th, 2024, did then and there operate a motor vehicle in a public place while the said defendant was intoxicated against the peace and dignity of the state.
Hey, Mr. Odebert, how do you plead? Okay, you may be seated. State, would you like to have an opening statement?
Yes, sir.
Okay, Mr. Hubel, you may proceed.
Please, court.
Yes.
Good afternoon, everybody, and thank you all for being here. As both, defense and state emphasized yesterday, without y'all, the criminal justice system, could not, function. And that function that y'all had this week is making a decision, an important decision on this case. So to make that decision easier for you, the purpose of this opening statement is to give a roadmap of what y'all can anticipate in the trial ahead and, how the state will prove its case. Now, the important part, to start with is the elements that we have to prove beyond reasonable doubt. That this offense took place in Jefferson County, that happened on or about a certain date, that date being March 7th, 2024. That the defendant, Logan Odeberg, is the individual who, committed the act in this case. That act being that he operated a motor vehicle in a public place in our county while he was intoxicated. And you'll remember yesterday, that there was discussion about what intoxication means. Intoxication means either the loss of mental or physical faculties based on the introduction of intoxicating substance. They can be drugs, alcohol, or any other substance that would alter the mental or physical faculties of the individual. And the third basis by which intoxication can be proven is a blood alcohol concentration of 0.08 or more. Now, we can also comment during these opening statements on what we believe the evidence will show. And what the state believes the evidence will show in this case is that in the early morning hours of March 7th, 2024, just after midnight in Clearwater, Texas, which is in Jefferson County, Texas, that the officers Corey James and Thomas Roberson were on patrol. They're driving down Gulfway when they happened upon a vehicle that they noticed did not have their headlights on. And as mentioned earlier, this is just after midnight, in the dark of night. It's a traffic violation, and not to mention a dangerous one, to be driving around for up at night without lights. So the officers decide to pursue the vehicle, which they execute a U-turn in order to do so. And which the suspect vehicle, then we believe the evidence will show, turns off onto the side street. When the officers eventually come behind the vehicle at that point, the defendant is turned on the headlights of their vehicle, having been noticed, and then turns into a driveway. Upon entering that driveway, the defendant attempts to exit the vehicle, and the evidence will show that Officer James prevented the defendant from exiting that vehicle, manner of officer safety at that point. And as for his identification, enters his information. And at this point, the evidence will show that the defendant was showing signs of intoxication, slurred speech, incoherent sentences. And when the officers ask him to get out of the vehicle, the defendant makes certain admissions about the evidence will show that he said he's coming from a friend's house, that he had been drinking, specifically Four Locos and Crown prior to driving. You can also see, you will also see, we believe the evidence will show in the video that the defendant was unsteady on his feet and needed to brace himself for balance. After at this point, the Officer James asked the defendant to perform what are called stated as a sobriety test, which we'll go into greater detail of that in direct testimony. But the examples of the tests that were performed were the horizontal gaze and stagnance test, one that you might have seen either in media or in person before. The log and turn and the one leg stand, during which the defendant demonstrated many signs of intoxication. And following those tests and the observations that Officer James made previously during his investigation, the officer makes the decision to arrest the defendant for GWI. The defendant is given an opportunity to submit a sample for a blood draw. He refuses that, and as is required, the officer seeks a blood warrant. A sample is obtained at the Jefferson County Jail, witnessed by both officers, and performed by a registered nurse, Isaac Magugla. And Officer James then places those tubes in what's called a blood kit, where they're transported to property, and then later tested by the Jefferson County Regional Crime Lab. We believe the evidence will show that the results of that examination and the time of testing, that sample was above a 0.08 blood alcohol concentration. Now, and you may notice that I mentioned Officer James a lot in this opening statement, but not really a huge mention of Officer Roberson. It's because he's unavailable this week due to medical emergency with his family. But to prove its case beyond a reasonable doubt, the state will be calling Officer Corey James, the lead officer, will be here to testify to the traffic violation leading up to the stop, what happened on the stop, the signs of loss of mental and physical faculties that he witnessed throughout the investigation and during the administration of the SSTs. He'll be here to sponsor his body worn cameras, so you'll be able to view the traffic stop, the interaction, and the blood draw itself that took place later at the jail. And Melanie Altamirano from the Jefferson County Crime Lab will also be here to testify to her qualifications and experience as a blood alcohol toxicologist. The conditions and certification of the lab in which the test was performed in, her process, her scientific analysis, by which she conducted the test, and the results of that analysis. And with those witnesses and those evidence combined, the state will prove to you beyond a reasonable doubt that on March 7th, 2024, in Jefferson County, defendant Logan Odeberg operated a motor vehicle in a public place while intoxicated. Thank you. We appreciate your time and attention this week.
Gentlemen,
I'll reserve mine.
reserve it. Okay. Ms. Nixon, would you like to call your first witness?
Yes, Your Honor. State calls Officer Corey James.
Corey James. Okay. Officer James, would you please come forward? Officer James, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Okay, you may put your hand down, Officer James. Officer James, you can take the witness stand. You can adjust the microphone and the chair if you need to.
Good afternoon. What's your full name?
Corey James?
Are you a certified peace officer?
Yes, ma'am.
Where are you presently employed?
For the police department,
And how long have you been employed by the police department?
3 years.
3 years. What are your duties in your present position?
Patrol officer.
Okay. Can you describe your educational background for me?
College, police academy, and high school diploma.
Okay. Have you had any special training pertaining to your duties as a peace officer?
Yes, ma'am.
Okay, and what were those?
SRT rifle school, and that's about it.
Okay. Had you had any special training pertaining to the detection of the signs of a person who's intoxicated?
Yes, ma'am.
Okay, and what was that?
Throughout the academy is a long process of them showing you how to detect intoxicated subjects and also how to perform the STs.
Okay. Were you employed as a peace officer with the Port Arthur Police Department on March 7th, 2024?
Yes, ma'am.
Were your position and duties the same as they are now?
Yes,
How long did your shift run?
10 hours.
10 hours. And what were your duties on your shift that night?
Patrol.
Okay. Were you in uniform?
Yes, ma'am.
Were you in a marked police vehicle?
Yes, ma'am.
Okay. Were you working alone or did you have a partner that night?
I have a partner,
Okay. Who was the partner?
Officer Roberson.
At about 12:06 a.m., did you observe anything out of the ordinary?
Yes, ma'am.
Okay. What did you observe, sir?
I observed a passenger car coming up northbound on one of the side streets without any lights.
Okay. Is driving no headlights at night a traffic violation?
Yes, ma'am.
Okay. And based on this violation, did you decide to pursue and stop this vehicle?
Yes, ma'am.
Okay. During that pursuit, was your vehicle's dash cam operational
Yes, ma'am.
and active? Okay. What type of vehicle did you pull over?
Honda.
A Honda?
Hyundai.
It's a Hyundai?
Yes, ma'am.
Okay. Is a Hyundai, motor vehicle?
Yes, ma'am.
Okay. Where was your car in relation to Hyundai whenever you first observed it?
I was traveling eastbound, it was coming north, so I passed them up.
Okay. At any point, did you notice the driver turn their headlights on?
Yes, ma'am.
Okay, when did they turn their headlights on?
As he made a turn onto one of the streets before he pulled into the driveway, he finally got the headlights.
Your Honor, may I approach the board?
Yes, you may.
I'm showing you State's Exhibit 1. You know what this is?
Yes, ma'am, so that's it.
Okay. Did you watch this recording?
Yes, ma'am.
Was this recording prepared on a device that's capable of making an accurate copy of events?
Yes, ma'am.
Are you a competent operator of the device that it was made on?
Yes, ma'am.
Okay. Is this recording a fair and accurate copy of what happened that night on March 7th, 2024?
Yes, ma'am.
Okay, and has it been altered in any way?
No.
State would like to offer State's Exhibit 1.
Yeah.
Your Honor, this time I would object and was obtained in violation of the defendant's right to be free from unreasonable search and seizure, specifically the traffic stop was not predicated on reasonable suspicion, there was no traffic violation. Secondly, the tape contains inadmissible statements of the defendant that occurred during custodial interrogation prior to being Mirandized.
Okay. Okay, ladies and gentlemen of the jury, at this time, we're gonna ask that you step outside. We have to have a hearing outside of your presence. You can follow the bailiff into the hallway. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 24 CCCR 1826. Case style of state of Texas versus Logan Odebert. Let the record reflect that Mr. Odebert is present in court with his attorney, Attorney Wright Kimler. State is present with Assistant Criminal District Attorneys, Attorney Farrah Nixon, and Attorney Andrew Hubel. Let the record also reflect that the jury is now present and seated in the courtroom. And Mr. Kimler, your objections are overruled. Ms. Nixon, you may proceed.
State amendments, state 61
Yes, like to publish it?
Yes, can I publish it to jury, please?
Yes.
Oh man, with the lights on.
No,
Somebody leave it.
just, we'll see.
Okay.
This is just the, videotape of the initial traffic violation. They're turning around, the U-turn, and then you'll see the defendant's car far ahead. And when he takes a turn on the right, you'll see that there's no lights in front of his car. But he's very far ahead. He's up here. So, Officer James, can you explain what happened on that? I shouldn't have done.
So
Can you explain what happened whenever you pulled him over?
prior to the stop,
Yeah, prior to the stop.
I observed him driving north on one of the side streets with the red lights. I made a U-turn, when he said the traffic stop. He was possibly maybe about 3 blocks ahead of me. As he got on the stillway, he made a little left-hand turn. He goes to the driveway, he finally activated his hip.
Do you see the driver of the vehicle in the courtroom at this time?
Yes, ma'am.
Could you point to where the person you recognize as the driver is sitting and identified by a article of clothing?
Right there, he had a black blazer and black shirt.
Your Honor, may the record reflect that Officer James has identified the defendant, Logan Odebert.
The record reflect that the witness has identified the defendant, Logan Odebert. You may proceed.
And Officer James, as you're traveling down the drive trying to catch up to where the defendant was, were you in Jefferson County, Texas?
Yes, ma'am.
Okay, and is Gulfway Drive a public place?
Yes, ma'am.
Thank you. Can you explain how you approached the vehicle?
As I exited my patrol unit, I made a passenger side approach, I made a driver's side approach, my partner made a passenger side approach.
Did you have your body worn camera active during the stop?
Yes, ma'am.
Okay. What did you ask the defendant?
I've asked him where was he coming from and also if he had anything to drink.
And how did he respond?
He stated he was coming from a friend house and he stated that something.
Okay. Did he give you his license and insurance for the stop?
He did not give me a license.
Okay. When you're speaking to the defendant, what did you smell, see, and hear?
I smelled the odor of an alcoholic beverage. He had slurred speech. And that's about it.
Did you see anything else about the defendant?
He had glossy red eyes.
According to your training experience, are these all signs of intoxication?
Yes.
Okay. Was the defendant under arrest or detained at this time? Okay. And did the defendant admit to drinking alcohol?
Yes, Your Honor, it's been established that this is a result of a custodial interrogation prior to being ran notice. You said it was detained.
is retained for investigation.
Or is it already in court that amounts to a custodial situation?
No, Mr. Kimber, would you like to take this witness on for an
Briefly, huh?
Okay.
Kind of help.
Ms. Nixon? Good afternoon.
You say he was detained, he wasn't free to move, is that right? Wasn't free to leave?
Yes, sir.
That is, appeared to be at a residence, is that right?
Say that
He
again.
appeared to be at a residence, you were located at a residence during the stop, is that right?
Yes, sir.
Wasn't free to go inside of the residence?
No, sir.
Was he handcuffed?
No, sir.
Was he moved or directed to go to a particular place by you?
Yes, sir.
Where,
To the front of my patrol unit.
was he ordered to place his hands on the unit?
Yes, sir.
What other directions did you give him during the detention as far as his physical, limitations on his physical mobility?
When I asked him to step out of his vehicle, I asked him to place his hands up so I can conduct a officer safety pat down. That's why I located his wallet and his ID. And then I instructed him to step in front of my patrol unit.
So you're referring to what's commonly called a Terry search?
Yes.
What specific articulable facts did you have to indicate there was some danger to your safety when you conducted the Terry pat down?
As I walked up to his vehicle, I didn't know he had a firearm on his, any type of weapon or firearm on his person.
So the absence of evidence is evidence? What specific facts did you observe to indicate that there was a danger to your safety?
It's a standard practice for officer safety.
So you didn't observe any articulable facts before you conducted the pat down search to indicate to you that your safety might be impaired, is that correct?
No, sir.
Did you locate any contraband or anything else on him during the pat down search?
On him?
Did you open his wallet?
Yes, sir.
That was a search of his wallet, and
I asked.
you
I
gave,
asked him what was this. He stated it was wallet. I asked him to open it. He said yes. I asked was his ID inside. He said yes.
so was that when he was back at your unit or not?
No, sir. Still at the car.
Okay, so he was detained at the time you did that, is that right?
Yes, sir.
And you had probable cause to believe that he was intoxicated at that time. You indicated that there was observable facts to indicate intoxication. So he was in custody based on those custodial facts.
Yes, sir.
Okay. That's what John Rear objected.
Okay, now, did you have a response to his, he reurged his objection?
Can you restate your objection?
I would object to any statements he made in response to questioning by this officer after the custody was established. The officer refers to it as a detention. I would argue that it's a custodial situation. Therefore, implicating Miranda, which the officer failed to give, so any subsequent answers that the defendant provided while in this custodial situation should be suppressed.
Officer,
Who's responding?
Your Honor, this is a temporary investigatory detention. If the defendant did not present further signs of intoxication after the investigatory detention, he would have been free to leave. State would urge that this is not the type of custody that Miranda rights attached to.
I believe I heard the state conceded it was a custodial situation, Your Honor.
Okay, objection sustained. The officer stated it. Okay. Okay, you may proceed with your next line of questions.
Commissioner, what point
He objected to
custodian?
the statements made by the defendant while he was in custody, custodial interrogation, any interrogation during his custody.
was it determined that he was in custody?
Mr. Kimler,
The point that he was physically moved from one point to another, Your Honor, I believe establishes the custody.
I think the officer stated during the when he took the witness on voir dire, the witness stated that at some point he was in custody, according to his response to Mr. Kimler's questioning. Hold on a minute.
Take a brief recess.
Okay. Okay, ladies and gentlemen, we'll take You don't have to stand, you're on the witness stand.
There's a lot more.
You may be seated. Jefferson County Court, Item number 2 is back in session. The court is in session and calls number 24 CCCR 1826. In the case of Style State of Texas versus Logan Odebert, let the record reflect that Mr. Odebert is present in court with his attorney Private Kimberly, State is president of the Assistant Criminal District Attorneys, Attorney Farrah Nixon, and Attorney Andrew Hubel. Let the record also reflect that the jury is now present and seated in the courtroom. State, are you ready?
Yes, Your Honor.
Defense, are you ready?
Great.
Okay, Ms. Nixon, you may proceed.
Thank you.
You're welcome.
Officer James, did you ask the defendant to get out of the vehicle? Why did you ask him to?
At the time that, legal suspicion that he was under the influence of alcohol.
Miss Officer, could you speak up or you can slide up and speak into the microphone? Thank you.
But,
Yes,
at the time of, I had reasonable suspicion that he was under the influence of an alcoholic beverage.
Okay. How did the defendant move after leaving his vehicle?
After he got out of the vehicle, he was having difficulty maintaining his balance.
Okay. Did you ask the defendant to perform field sobriety evaluations at the scene?
Yes, sir.
Okay. Did the defendant appear to be disabled or injured in any way?
No, ma'am.
Okay. What test did you have him perform?
Horizontal gaze steadiness, a walk and turn, and also one extent.
Okay. So what was the first one you had him perform?
I conducted HGM.
Okay. Did you explain how the test was to be performed?
Yes, ma'am.
Okay. Did the defendant attempt to perform the test?
Yes, ma'am.
Did the defendant successfully complete the test?
No, ma'am.
Okay. In what way did the defendant fail to perform the test properly?
At the beginning of the test, I gave him instructions not to move his head and to follow the stimulus with his eyes. He continuously moved his head, and I was able to observe the stagnance in one of his eyes.
Okay. Play part of this. This is just the. So what field sobriety test is he performing at this point?
I'm conducting HGM.
Can you all see? the second test you asked him to perform?
One time.
Did you demonstrate this test first?
Yes, ma'am.
Did you explain how this test was being performed?
Yes, ma'am.
Did the defendant perform the test?
Yes, ma'am.
Did the defendant successfully complete the test?
No, ma'am.
Okay, in what ways did the defendant fail to complete the test properly?
He stepped offline and he also was going for California.
Okay, we'll watch that. What's the defendant supposed to be doing during this test?
Supposed to be maintaining the starting position. And as the test goes on, he's gonna take 9 of those steps down the line. Once he comes to his 9th step, we'll take a series of small steps to turn back around and repeat. Also, he would have to keep his one arm by his side as he walks, which I'm allowed.
Is that you demonstrating?
Yes, ma'am.
And to reiterate, he's supposed to have his hands by his side.
Yes, ma'am.
What's the third test that you asked him to perform?
Exam,
I'm sorry.
the one leg exam.
Did you explain how to do this test?
Ma'am.
Did you demonstrate it before you finished?
Yes.
Before you asked him to take it? Okay. Did he attempt to perform the test?
Yes, ma'am.
Okay. And did the defendant successfully complete the test properly?
No.
How did he not complete the test properly?
We just put it down multiple times, we also use the going over values and using the possibility of the very safe.
Okay. And so whenever he's doing this, you said he has to put this cap down his arms to the side.
Yes, ma'am.
That you sorry, is that you demonstrating
Yes, ma'am.
one leg stand? And just to reiterate, during that test, is he supposed to keep his arms to his side?
Yes, ma'am.
In your opinion, does it diminish the reliability of field evaluation tests if the defendant was nervous or hadn't practiced the tests? Okay. Did you arrest the defendant for driving while intoxicated?
Yes, ma'am.
Why did you place him under arrest?
Because he failed to perform standard field sobriety test to the satisfactory level. He was intoxicated.
Okay. Were there any other signs, symptoms of being intoxicated?
Yes, ma'am.
Okay, what were they again?
He had widespread slurred speech, and was unable to maintain balance.
Through your training and experience, do you believe the defendant lost the use of his normal mental and physical faculties?
Yes, ma'am.
Do you believe it's due to the introduction of alcohol?
Yes,
Okay. Um, I should have got me approach the.
Yes, ma'am.
Okay. States exhibit 2, do you know what this is? So I can speak up.
it's not vital.
Have you watched this video?
Yes, ma'am.
Okay. Was this video prepared on a device that is capable of capturing an accurate events that happened?
Yes, ma'am.
Okay. Were you a competent operator of the device that we used to capture this video?
Yes, ma'am.
Is this a fair and accurate copy of the events that happened on March 7th, 2024?
Yes, ma'am.
Okay. Has this video been altered in any way? State offers exhibit 2.
Your Honor, Rear's objection is predicated on illegal traffic stop resulting in an illegal detention of the defendant in violation of his right to be free from unreasonable search and seizure.
Objection overruled. You may,
Maybe.
yeah, you
Publish
publish
to
to
the
the jury.
Thank you, Your Honor.
Recording.
Yeah. You go stay in the car, don't get out. Where you come from? All right, the reason why I'm asking you that is when you put out on the busway, you didn't have your headlights on. You had no lights on. Oh. No, hey, if I did, cause I did see the turn something now. And so they automatic turn off. That's the thing. Okay, man, automatic turn off. Still doing 50 Street. I just left the brand house. All right, you got the license and registration, license and insurance? Yes, sir. I got the best thing, the state control, and then no license, my dog. No license? Oh, sir. Okay, so the same if I need to name that first, all right? Yeah. So next put these man at the print out on 15, what you doing? I really was just sitting over there hanging out, and I decided I got bored and I left. Oh, yeah. Come on, go to the. Okay, why y'all saying nothing to doing like? Go to the details, what I'm talking about, everything is great. Probably went to sleep. Everything is great. What's a little bit? One beer, two beer. One, two beer. Kind of beer. Beer. Kentucky, Bud Light, you know. Yeah. Eat anything? Nah, I'm gonna do right there, bro. Okay, so when was the last time you ate? What was the last time you drunk? I ate when I drunk a little bit. I just stayed over there and just chilled. I didn't really stay that long. I stayed that long, but I was like sleeping. Alright, so then I woke up and we were ready to do.
James, using your training and experience, would you say that this gentleman was presenting with clear speech?
No,
Okay. How would you describe it?
slur.
Okay. Is this another angle of whenever you party the HG? Yes. Is this where you're instructing on the walk and turn test?
Yes, ma'am.
Mhm. Is this where you're demonstrating?
Yes, ma'am.
Where you're giving him instructions on how to do the one leg stand?
Yes, ma'am.
James, when you have the different, the patrol vehicle, did you read warnings regarding giving sample of his blood or breath? Okay. Did you request the defendant to give you a sample of his blood?
Yes, ma'am.
Did you or your partner have to apply for a blood warrant to get a sample?
My partner did.
Okay. What does the process entail to get a blood warrant?
Say the last part of me.
Sorry, what does the process entail to get a blood warrant?
You have to fill out a statement and send it to a judge. On that statement, it has to state the causes of the stop, the things you observed, if he completed SFSTs, and if he also refused.
Okay, thank you. May I approach the witness room?
Yes, you may.
I'm gonna show you what's marked State Exhibit 3. You know what this is?
Yes, ma'am.
Did you watch the video on this?
Yes, ma'am.
Was this video prepared using a device that could capture an accurate copy of events?
Yes, ma'am.
Are you a competent operator of the device it was captured with?
Yes, ma'am.
Okay. Is the video that's on here a fair and accurate copy of the events of the night of March 7th, 2024?
Yes, ma'am.
And has it been altered in any way?
No, ma'am.
State offers State's Exhibit 3.
Oh, this is the blood draw. No objection to the video of the blood draw.
Okay.
That's not, I'm not conceding the blood draw itself. We were kind of the video of the blood.
Okay, State's Exhibit number 3 is admitted.
May I publish it to the?
Yes, you may.
Dr. James, where are we at?
Recording.
We're at the jail, county jail.
What are you doing to this box here?
Just checking the box to make sure it hasn't been opened.
Um. Sorry. Where was the defendant taken after he was arrested?
To Jefferson County Correctional Facilities.
Okay, and was this where the blood sample was taken?
Yes, ma'am.
Where specifically in the Jefferson County was it taken?
In the infirmary.
Was it a sanitary place?
Yes, ma'am.
Okay, who collected the sample for Mr. Overbert?
R.E.N. Isaac. I cannot pronounce his last name.
Buda?
Yes, ma'am.
Was he a trained professional?
Yes, ma'am.
Okay, did you see the nurse take the sample?
Yes, ma'am.
What time did they take it?
01:30.
And did the nurse hand you the tubes after they were drawn?
No, ma'am.
Who did they hand them to?
Officer Rose.
Is that your partner?
Yes, ma'am.
In your report, you wrote that you inverted the tubes and placed them in the blood kit.
I did not invert them. Officer Rosen did, but I did place them inside the blood kit.
Regardless of who inverted it, they were inverted and placed in the spot. Okay.
Yes, ma'am.
So you inspected the blood kit to make sure it was enough to get. What are you doing here?
Expecting the file, so any cracks or any damages.
Are you expecting for anything else?
White powder inside of the vials.
What are these labels that you're filling out?
They go over the tubes. So after the blood draw is conducted, you place them over the tube and you place them back into the slip and back inside the vials.
Another time, huh?
And what's the label you're filling out?
And typically sealed,
What does that mean? What is it used for?
it's used to seal the box back up until it gets to the lab and it's reopened.
I'm showing you, oh, sorry, I first.
Yes, ma'am.
I'm showing you what state has market spaces if it's more, you know what this is? No. What is it? How do you recognize this?
They still have my name in the bathroom, so.
What did you do with this after you baked through the tubes and you sealed this?
Basically evidence into the side and then I got water, which keeps it cool.
Okay, has it been tampered with any manner?
Since I placed it in there,
Yes.
it's been sent to the lab and opened this one.
Okay. Who picked this up today?
I did
Where did you pick it up from?
evidence,
Evidence where?
for the police department.
We have the. Can you open this? So it's sent to the lab, of course, it's lab. You recognize the contents of the box.
Yes, ma'am.
Okay. Are these? You just have to open it and verify if those are the vials that you placed in there the night of March 7th, 2024. Does that one still have it sealed intact?
Yes, ma'am.
Does it still have identifying marks on it?
Yes, ma'am.
Are they your identified marks?
Yes, ma'am.
Okay. Let me see that right there. You can just hand out. I'm just going to table. Just marking this. We'll call this say exhibit 4A. Let's see that, so please.
That's nice.
This one.
I won't go on and see.
See this one. What's the label read there?
Sample taken up, I haven't seen the name.
Okay. So 4A. The seal is not intact. The 4B, that one's intact.
Yes,
All of those state exhibit 4B. State's not going off into exhibit yet.
Okay.
Except 4B.
Yeah, yeah, states 4A and 4B.
Yeah, 4 is the big hit, 4A and B. Well, thank you, Dr. James, absolutely.
Say, John,
Yes.
you review anything in preparation for your testimony today? Did you review anything in preparation for your testimony today at your report?
Yes, sir.
You have it with you?
Yes, sir.
You might have to take a look at it. Just that other place where you go.
Thank you, listen. Yeah, sir.
Anything else besides this?
No, sir.
You were driving the patrol unit, is that right, or were you the passenger?
I was driving.
So was it, what time was this at?
The initial stop.
Yes. What was the time that you stopped, that they said to stop?
That part I do not recall.
Thank you, look, would it help you to review your report? What time did you initiate the stop?
That is not on the page.
Is it on your report?
Yes,
At what time did you initiate the stop?
06.
What was that, 12:06 a.m.?
Yes, sir.
So basically midnight,
Yes, sir.
and you were going, eastbound or westbound on Beltway?
Eastbound.
And the car was traveling eastbound or westbound?
Which
The
one?
subject vehicle,
He was traveling north.
north on what street?
He's not in the report.
What do you recall?
I do not recall the street.
Recall what block of Beltway you were in approximately?
Oh, 1400.
So you would be east or west of 9th Avenue?
That's west of my Avenue. That's way west.
Way, that's your 14th Street? So way west of 9th Avenue then.
9th Avenue is a 3600 block.
Right, so you would be west of 9th Avenue?
Yes, sir.
And you don't recall which street it was on? It's one of the side streets?
Yes, sir. I recall him turning on the Stillwell.
Off of what street?
He can't turn off the Gulfway. He came off to Gulfway and turned on the Stillwell.
So when you first saw the subject vehicle, he was traveling, eastbound on Beltway?
He was traveling north.
On what street?
I don't recall that street.
And you were able to visually identify that the car was being operated without the headlights?
Yes, sir.
Did you maintain constant visual contact with the vehicle prior to the stop? Or did it ever escape your field of view?
I lost fuel review for approximately maybe about 30 seconds as I turned around.
Are you, when you turned around, did the vehicle, was the vehicle, were the lights initiated or not?
No, sir, when I turned around, it still had the lights on.
So during the period of time that you lost field of view, the lights, were still off, is that right?
Yes, sir.
And when it returned to your field of view, the lights were still on?
So that's
When it
why,
returned to your field of view, the lights were still off? You observed the lights to be off when it returned to your field of view?
Yes.
After you lost sight, is that right?
yes, sir.
When did you see the headlights come on?
As I turned onto Stillwell and he was turning off of Stillwell.
The lights came on?
Yes, sir.
What were the visual, conditions during that time? Were there street lights illuminating the scene or not?
As he was coming off the side street going north, no, sir. Certain parts of Port Arthur in certain areas, especially in that district, right there where he was at, the street lights don't work that well, or they're very dim.
Why is that? Why are they dim or don't work?
That's a sick question.
You don't know?
I don't know.
I mean, have it been tampered with or it's just the city's fault? You don't know
I
that?
don't know.
So based upon your observation that the headlights weren't being operated after dusk, what violation of transportation code is that?
It's a traffic violation. I cannot recall the actual, section number for it. It's like in the files.
You don't know?
I don't know at this time.
Did you cite him for that violation?
No, sir.
Didn't write him a ticket?
No, sir.
Why not?
Because he was driving intoxicated.
So you felt it was what, redundant or unnecessary to cite him for the traffic violation?
Yes, sir.
So you turned into a private driveway, is that right?
Yes, sir.
And I guess at the end of this, you didn't tow the vehicle?
No, sir.
When you approached the vehicle, I guess your partner was on the, passenger side approach?
Yes, sir.
And I believe we saw in the video that the driver's side door was open, is that correct?
Yes, sir.
So Mr. Odeberg was attempting to exit the vehicle when you were making the stop when you first came up on him, is that right?
Yes, sir.
And that's when he see you do the approach, correct?
Yes, sir.
He produced, a Texas identification card, is that right? Or was it a driver's license?
I don't recall what it was, but I know it was expired.
Okay, so maybe a license that was just expired, or you don't remember, or was it identification? Was he cited for operating a motor vehicle with an invalid license?
No, sir.
Did you obtain insurance on the vehicle or not?
No, sir.
Did Mr. Odeberg, as far as complying with your instructions, would you agree with me that he substantially complied with your instructions? He provided you with the license and insurance and obeyed your commands, your lawful commands?
On the first one, initially asking him for his license, he said he didn't have one.
Well, he didn't, that was accurate, he was expired, is that right?
It's still a license.
Well, it's expired, and we assume that you meant a valid driver's license when you asked the question, correct? Did you ask him if he had a valid driver's license or a license?
I asked him if he had a license. At the time, I just wanted an idea.
And he produced an expired license, is that correct?
Yes.
And indicated he didn't have a license or a valid driver's license, correct?
Yes.
So that was accurate information, he wasn't providing false information, right?
No, sir, it was not.
You indicated that you thought that, you observed a slurred speech or some sort of impediment with his speech, is that right?
Yes, sir.
You familiar with his normal speech pattern?
No, sir.
But based on your training experience, you believe it to be what, slurred as a result of the introduction of alcohol?
Yes, sir.
Did you detect the odor of an alcoholic beverage?
Yes, sir.
Strong or mild, medium, what was the level?
It was strong enough from where I was standing at, I could smell it.
Was it emitting from his person or from the vehicle?
It was person.
So at that time, you believed that he was under the influence of an alcoholic beverage, is that right?
Yes, sir.
You believed he was intoxicated at that point, or would you need to do further investigation?
I did further investigation.
My question is, did you believe him to be intoxicated at that point, or did you feel it necessary to conduct a further investigation?
I felt it was necessary to conduct a further investigation.
So you didn't believe him to be intoxicated, you suspected intoxication, but you didn't believe he actually was at that point, is that right? You hadn't formed that conclusion yet?
Yes, sir.
Are you familiar with what the definition of intoxication is in Texas?
Yes, sir.
What is it?
It is. Jesus, I just looked at it.
It's kind of hard when you're under pressure, right, to remember?
Yeah.
Can you remember? What is it just basically? You don't have to look hard, just tell me.
It's not having the normal motor skills or
Not having normal use,
normal use of body movements and stuff like that.
not having normal use of physical mental
You know,
Yes.
capacity at having something abuse into the body.
alcohol, drug, controlled substance.
Yes, sir.
Combination, right?
Yes, sir.
It's not having normal use of physical or mental faculties because of alcohol and drugs, right?
Yes, sir.
So if someone's intoxicated, you think that they're capable of making rational decisions? If they don't possess the normal use of their mental and physical faculties, would they be capable of making rational decisions?
No, sir.
So they wouldn't, right? Did Mr. Odeberg, comply with your request to perform the standardized field sobriety test?
Yes, sir.
And explain to the jury what the standardized field sobriety tests are.
You want me to explain the whole test or
Just what they are in general, what the standardized FSTs are.
Standard field sobriety test is a test that diverts your attention as you do it. If you're not intoxicated, you should be able to perform the test. If you're intoxicated through any alcoholic beverage or narcotics inside of your body, it makes it more important to perform the test.
That's your understanding of it? Are you certified to administer the test?
Yes, sir.
When were you last certified?
I was certified in the academy. I just can't remember what month.
And how long was it from your certification in the academy to administering the test in this occasion?
To him,
Yes, sir.
probably about a month.
So you were out of the academy a month when you made this traffic stop?
Yes, sir.
Okay. So you weren't in your field training period, your FTO period?
Yes, sir.
You were, the other officer was your FTO.
Yes, sir.
Okay. And explain to the jury what an FTO is.
The field training officer, they're with us in training to make sure we don't make any mistakes. If we make a mistake, they kind of guide us through it.
So basically, you're in your 6-month FTO period when you do this investigation, is that right?
Yes, sir.
And you're being supervised, what's the other officer's name?
Roberson?
Robinson, being supervised by Robinson. But he was letting you conduct the investigation, right?
Yes, sir.
So let's start with the horizontal gaze nystagmus test. What is that?
It is a test to show you by the eyes. The eyes, they do an involuntary jerking and shoot out alcohol inside of the eye. So as you go with the lax smooth suit, the eyes can just involuntary jerk. As you go to prior to 45 degrees, the farther you go out, well, not farther. As you started, before you make it to 45, if the eyes are jerking, it tells you about how much alcohol you have in your body.
Well, it's indicative, right? It doesn't give you a particular number, it just indicates the presence of alcohol, is that right?
Yes,
It's not an intoxication test per se, correct?
yes.
You agree with that?
So that's why you,
It's not, it doesn't test for intoxication, it just tests for the presence of alcohol. Do you agree with that?
yes.
Now, what's the next test?
As
Of the 3 standardized field sobriety tests?
the walk and turn,
9-step walk and turn, right?
walk and turn.
You don't call it the 9-step walk and turn anymore?
It's called walk and turn.
So there's no set number of steps anymore, it's not 9?
It's
That's how
called-
you were trained?
It's called the walk and turn.
Right, but there's not a set number of steps anymore, like 9 steps? It's
Tell
not-
them you have to take 9 heel toe steps, but as you refer to the name, it's called the walk and turn.
Okay.
Walk and turn.
During the instruction period of the test, you instruct the person, especially on this occasion, Mr. Odeberg, did you instruct them that it was 9 steps,
Yes, sir.
heel to toe,
Yes, sir.
attempting to walk a straight line, not using your arms for balance, right?
Yes, sir.
Arms to the side, you gave them those instructions?
Yes, sir.
Did you make any observations about the physical condition of Mr. Odeberg's legs, any kind of physical impairments? Would you inquire if he suffered from any physical impairments that would impede his ability to perform the test?
Yes, sir. I asked those questions.
What did he tell you as far as his physical
He said he
disability?
had no injuries.
Did it indicate to you that he had problems with his legs?
No, certainly not.
That's your recollection?
Yes, sir.
Did he appear to have some kind of physical difficulties performing the walk and turn?
Yes, sir.
And you attributed that, and what clues did you observe as far as intoxication? Which one?
When you place him in the starting position, they're told not to move from the position. He moved, he broke the stance, he picked up his arms.
That's during the explanatory period?
Yes, sir.
So he broke his stance during the explanatory period, that was one clue, is that right?
Yes, sir.
And what did you observe next?
I instructed him to take 9 toe steps down the line. He did not walk down the line, maintaining his balance. He was going off balance.
So how many clues was that?
I made 3.
3 on the walk and turn?
Yes.
And then you completed with a one leg stand, is that right?
Not yet. He didn't complete the test of the walk and turn yet.
Okay, well, go ahead and continue to explain,
As he kept
observe clues on the walk and turn.
As he kept going down the line, he was told to take a series of small steps. He just completely turned around and take a series of small steps. That's 4.
Okay,
As he went back down the line, as he finished the test, he stops. So I'm at 4.
okay. And then
Then it was the 1 leg stand.
the one leg stand, not the one legged stand, right? The one leg stand,
1 leg stand.
one leg stand, explain that, what does that entail? You used to call it the one legged stand, that's maybe
The name's changed.
change, right? So what does a one leg stand entail?
The 1 leg stand, it makes them have to count and focus on their basically on their.
Well, this physically, what is required of a person that's being administered the one leg stand?
To stand on 1 leg and raise the other leg approximately 6 inches off the ground.
Point the toe,
And focus. Yes, sir.
look at the toe.
Yes, sir.
right? Hands to the side, count 1,001, 1,002, right?
Yes, sir.
To no particular number, correct? They're not instructed to count to a particular number, right?
Yes, sir.
What instruction did you give Mr. Odenberg?
I gave you the instruction to raise the leg approximately 6 inches off the ground. And once I told him to start the test, he was able to start, and then he could not stop until I told him to do so.
He didn't stop until you told him to stop, or what?
Yes, sir.
Well, that's what he's supposed to do, right? He's supposed to go until you tell him to stop, right?
Yes, sir.
Did he comply with that?
Yes, sir.
Based upon the totality of the circumstances that you observed at that time, I guess in consultation with Officer Robeson, you decided to arrest him for DWI, is that right? Is
Yes, sir.
that right?
Yes, sir.
Okay. And then transported him to the jail without incident?
Yes, sir.
And then at the jail, they already formed the opinion that he didn't have the normal use of his mental capacity because of alcohol, is that right? You had arrested him for that, right? You did because he didn't have the normal use of his mental faculties and was operating a motor vehicle, right? That's why he was arrested.
Yes, sir.
So at the jail, it was in your mind, you knew he did not have the normal use of his mental faculties, correct?
Yes, sir.
It's not a trick question, I promise. You arrested him because he didn't have the normal use of his mental faculties. He was impaired, right?
Yes, sir.
So his thinking is impaired, correct, when you take him to the jail?
Yes, sir.
At the jail, what did you ask him?
I don't recall asking anything.
You asked him something. What did you ask him?
I don't recall.
Did you hear? What did you ask him to do?
I didn't ask him at the jail.
What did you ask him?
I read him statutory warning and asked him, did he give me consent for his blood? And he
Was that-
said no.
Was that at the jail?
No, sir. It's not
Where-
at the jail.
Where did you ask him for consent?
In the back of the unit before he was transported.
All right, so before you got to the jail, you asked him for consent, after he was arrested, right?
Yes, sir.
I assume you were in jail, and you asked for consent. So after you formed the conclusion that that he had impaired mental functioning, you asked for consent, is that right?
Yes, sir.
Does that seem to make sense to you? What does consent, actual effective consent entail?
Yes.
What is effective consent?
Effective consent is anything given without being involuntary.
Well, if I twist your arm behind you, say consent to a search, is that a consensual search?
No.
What if you're somebody like, in the context of a sexual assault, if a male or female is impaired by alcohol, and there's a sexual act performed, and they're under the influence, they're intoxicated, is that a consensual act or not?
No.
So if someone is asked to consent to a blood draw when, by your own admission, their mental capacity is impaired by alcohol, is that an effective consent?
No, sir. That's all warning was gathered.
So it's not effective denial that he didn't effectively deny consent for the blood draw. Because he didn't have the mental capacity to deny the consent, right? To have effective consent or lack of consent. If he didn't have the mental, if he arrested him because he didn't have mental capacity, did he have the mental capacity to either give consent or not give consent?
If he gave consent, then we would not got a warrant, but he didn't give consent, so we just got a warrant.
Then the warrant was predicated on a lack of effective consent, right? That he did not give consent,
Yes,
and you asked him for consent.
yes,
And the warrant itself was based upon the observations that you made as far as the field sobriety test, the observations of the slur of speech, anything else? What else did you put in the probable cause affidavit?
glossy red eyes and all over, I know all the beverage get put in.
And that's an electronic warrant, right?
Yes, sir.
And this is probably at what time did you attempt to obtain the warrant?
I didn't attain warrant, officer.
Basically, so you're not familiar with the warrant procedure? I'd have to ask you. Officer.
I am familiar with it, but at that time, since I was still in training, I didn't have the access to
Okay, do you know what time the warrant was requested?
that part. I do not know.
What time was the blood draw?
1:30.
So roughly an hour and a half after the stop? If the stop was at 12:06 and the blood draw was at 1:30, hour and a half after the stop,
I was somewhere in between,
sir?
probably somewhere in between.
Okay. But your recollection is the blood draw was at 1:30?
Yes, sir.
And then you or Rosen handled the kit, it's,
As in the kid you were asking about the vials,
the vials, yes.
Officer Rosen,
You didn't shake the vials or invert the vials, that was him?
that was him.
Check the seals, all of that?
I checked the seal on the box.
All right, not the vials themselves.
I checked the vials.
What was the expiration date
On the box,
on the vials?
the vials,
Were they expired or no?
no, sir,
They were valid, they were expired?
they were valid.
Passwords.
Okay. Ms. Nixon, you have any questions?
Officer James, I just want to clarify directions that you're saying. Did you say you saw the defendant come off a side street onto Gulfway?
Yes, ma'am.
Okay. Then he traveled down Gulfway
Yes, ma'am.
and then he turned onto Stillwell.
Yes, ma'am.
Okay. And did you say that the stop was around 12:06 a.m.? Oh, you said 00. I don't know how to say that in military time. You said it a double.
0.
Okay, so it's 12:06 a.m.
Yes, ma'am.
Approximately how long does a traffic stop for duty to have investigation?
It varies.
Okay. Do you know approximately how long this one was?
From the time the initial stop to everything was completed
Until the arrest,
until the arrest,
or till the arrest.
probably about maybe, I can't give you a time.
Can you say that the blood draw was at 1:30,
Yes, ma'am.
and that was drawn after y'all had to obtain a warrant?
Yes, ma'am.
So 12:06, you started the stop, and then you had to do the entire STFs and the investigation. Then y'all had to go to the Jefferson County jail, apply for a warrant, and then have the blood drawn. Is that correct?
Yes, ma'am.
Okay. Thank you. That's all I know.
Mr. Kimber? Okay, may this witness be excused?
Subject to recall, Your Honor.
Okay. Officer James, you're excused. You can step down. And you have a blessed day. Ladies and gentlemen of the jury, this will conclude the testimony for today. Is that correct, State?
Yes, sir.
Okay, so we will go into recess until 1:30 on tomorrow. So you need to be back at 1:30 on tomorrow. Okay? Okay, everyone please stand as the jury exits the courtroom. You may exit. And y'all have a blessed day. Court will be in recess.
Thank you.